Welcome everybody to our event today, discussing the release of the Washington Center for Equitable Growth's transition report for antitrust enforcement and competition policy. We are very excited by the report and the group that wrote the report. Also, really excited for this event. I want to start a little bit with I'm going to start with some housekeeping notes, and then I'm going to introduce our speaker, and then I'll turn it over to Heather Boucher. So just quick housekeeping notes. As we're going through, feel free to post questions. Those should go in the question and answer box if they're about the substance of the report. If you're having technical or logistical questions, those go in the chat box. And also for questions on content, sort of substantive questions about the report, questions for the panelists, when you put those in the question and answer box, if you could give your first and last name and along with your institution or workplace, that would be great. Last housekeeping note, everyone should be aware this event is on the record and it's being recorded. So one of the many benefits I find of working for the Washington Center for Equitable Growth is I suspect it's a little easier for me to get Heather Boucher to speak at an event than it might be for other organizations, and that's it's great because I'm just a huge fan of my boss, and that's not because she's my boss. But Heather Boucher is the president and CEO and co-founder of the Washington Center for Equitable Growth, which was launched back in 2013. And Heather is really, this organization is what it is because of her leadership and her vision. And I know Heather would be the first to talk about how many other people in the organization have helped deliver on all of that. And that's absolutely right. But also, it's just been impressive for me to see how she's been able to lead this organization for the 3 years I've been there. Now, in addition to running the organization, she's published multiple books on all dealing with progressive policy and how to improve the economy and promote broad-based economic growth based on evidence. So her latest is a book called Unbound: How Economic Inequality Constricts Our Economy and What We Can Do About It. She's also the author of Finding Time: The Economics of Work-Life Conflict, and co-edited a volume of 22 essays about how to integrate inequality into economic thinking called After Piketty: The Agenda for Economics and Inequality. So I'm not always a fan of the New York Times, but I think they got it right when they said that Heather is, quote, at the forefront of a generation of economists rethinking their discipline. And what I've really learned from the 4 years the almost 3 years of working at Equitable Growth is how strong she is at both understanding and processing a wide range of policy research at the academic level, understanding the implications for policy and being able to translate that. And so I think she's just the perfect person to lead off the event. And right before, I want to do one last thing before I turn it over to her. I also want to thank, in the course of the report, not just my co-authors who have been incredible experience for me, but also the Equitable Growth staff who have worked tirelessly behind the scenes, both in producing the report and on this event. And so that's Shonda Williams, Ed Paisley, Maria Moreau, Chantil Lake, Natalie Ntundi, Erica Handloff, Dave Evans, Tyjan Conley, and finally, particularly Raksha Kapuram, who I work with on a daily basis, and is just did so much to make sure things got done and was helpful and allowed me to sleep at night. So with that, Heather, I'm going to turn it over to you.
Thank you, Michael. It's been a privilege of a lifetime to be able to launch and lead Equitable Growth, and it is in no small part because we have the best staff of any think tank in all of Washington D.C. And it's just a real honor to be able to be with you all here today. And thank you, Michael, for that kind introduction. I am really just so pleased to be able to welcome you all today to our event, Restoring a Competitive U.S. Economy, a Vision for the Next Decade. I'm glad that you're all able to join us virtually, and I look forward to the conversation we're going to have today. So when I think about the U.S. economy, I think about what new research tells us about the business of healthcare, especially in light of the coronavirus recession. And back in 2019, Equitable Growth published a paper by economists Elena Prager and Matt Schmidt. And in that paper, they showed that nurses and pharmacy workers' nominal wages are about 6.3% lower over the 4 years following a hospital merger than they would have been absent that merger. In other words, wages for frontline healthcare workers have stagnated as a result of concentration across firms. Now, that year in 2019, we also published a paper by Colleen Cunningham, Florian Eder, and Song Ma that found that approximately 6% of pharmaceutical acquisitions are what they called, quote, killer acquisitions. Now, there's a term for you, right? Killer acquisitions are those in which a firm acquires a product in development that could compete with their own product so that they can kill the product line and stifle innovation. So basically, they can kill their competitors. So in the paper, the authors point to Questcor Pharmaceuticals' acquisition of a synthetic drug from a Swiss company, Novartis. Now, back in 2000, Questcor held a monopoly over a drug used to treat rare epileptic diseases. And that drug was priced at about $40 a vial. In the mid-2000s, however, Novartis began developing a new synthetic version of this medication. So Questcor said, well, let's go buy them up. And they did. So today, that same drug costs $39,000 a vial. That is a whopping 97,000% increase in the price of that drug over 19 years. Had that merger been thwarted by antitrust regulators, the synthetic drug would undoubtedly have provided a cheaper alternative. Instead, Questcor shareholders win and consumers lose. Now, many economists, Thomas Philippon and others, and including our first in-house dissertation scholar, Jacob Robbins, have shown how this kind of high economic concentration is also behind the decline in US investment relative to profitability. All of this kind of research, it shows us that if we want to see economic growth that is strong, stable, and broadly shared, we need to contain high-end inequality and provide counterweights to concentrated economic power. One clear way to do that is to revisit our nation's antitrust enforcement. We need to ensure that markets are competitive and that startups and small players don't get gobbled up or shut out. And that is why I'm so happy to be with you all today, virtually, of course, to share this new report and to talk about the antitrust enforcement agenda for the next administration. So for the past 5 years or so, Equitable Growth has been working on these issues around market structure and competition. And we've seen them at the forefront of policy debates. And we've seen that there's been a lot of talk about whether or not there's a problem, what the problem is, but there's been less focus on how to solve the problem. And now with the new administration on the horizon, it's time to go beyond problem identification and really move on to the policy solutions agenda. So in that vein, Equitable Growth, led on this team by Michael Cadis, has assembled a top flight group of experts to articulate a vision for antitrust enforcement that can restore competition in US markets. The authors are well-respected economists and lawyers. They have experience within government, and they have delivered what I think is a bold and thoughtful vision. Their report reflects a coherent and systemic plan for restoring competition in the United States economy by addressing 3 major institutions: Congress, the antitrust enforcement agencies, and the federal government more generally. So their report and today's event helps focus the national discussion on how to solve the growing threat of market power. So I'm going to introduce the topic by spending a few minutes on the history of antitrust enforcement as a policy issue, a little bit about the current trends and their implications for today, and then why antitrust enforcement has been failing us. Finally, I'll introduce a little bit about what we're going to talk about over the rest of the session in the 2 panels that follow, and how federal agencies can optimize deterrence and the role of Congress and the executive branch. So, you might think that in a capitalist economy like we have here in the United States, what we call antitrust enforcement or competition policy would be central to our public policy debates. But it turns out the history is a little bit more complex. I'm not going to go into all the ins and outs, but I want to start during the dark years of the Great Depression of the 1930s, when courts were loath to enforce the antitrust laws because they were afraid that doing so would make it that much harder for businesses to succeed during those tough economic times. But this all changed with the arrival of Robert Jackson and Thurman Arnold at the Antitrust Division of the US Department of Justice. They initiated the most active period of US antitrust enforcement, bringing forth a number of iconic cases. They found a sympathetic ear on the judiciary, particularly from the Supreme Court under Chief Justice Earl Warren. By the 1960s, Justice Potter Stewart quipped that, quote, "The sole consistency that I can find that is that in litigation under the merger statute, the government always wins." But then, beginning in the 1970s, the pendulum swung back. Economists and lawyers, many of them from the University of Chicago, questioned the economics underlying antitrust enforcement. They savaged existing legal doctrine in polemics, most famously, Judge Robert Bork's book, The Antitrust Paradox, A Policy at War with Itself. These critics offered a very different vision for antitrust law. Big was not bad. Indeed, big was seen as possibly very, very good. Large companies, they argued, except in rare cases, could achieve and sustain success only if they were more efficient and could continually outpace their rivals. So they believed that we should be far more worried about over-enforcing competition rather than under-enforcing it. They promised that a more lenient antitrust enforcement would mean more competition, more growth, more wealth creation. These scholars, known as the Chicago School, radically altered judicial, academic, and enforcers' views. Last month, former Assistant Attorney General Bill Baer, who is with us today and is a co-author of the report, explained to Congress, quote, "We went from the, quote, government always wins, end quote, to a 25-year dark age where the government invariably lost." So where does that leave us? What are we to make of the promise of the Chicago School? Did less enforcement mean more growth for everyone? I think we can safely say that the answer is no. The evidence, in fact, is quite overwhelming, and it comes from a variety of sources and a variety of methods. When we launched Equitable Growth back in November of 2013, 7 years ago Monday, our goal was to advance evidence-backed ideas and policies in pursuit of growth that was strong, stable, and broadly shared. And we fund scholars around the country to investigate whether and how economic inequality in all its forms affects economic growth and stability. These are critical questions because the landscape in which we engage in economic activity has shifted dramatically. To put it bluntly, the landscape is vastly more unequal across most dimensions than it was just a generation or two ago. So over the past 7 years, Equitable Growth has awarded over $6.5 million to over 250 grantees nationwide in order to understand how high income and wealth inequality, as well as the rising concentration across firms, affects not just who ends up with the money, that is distribution, but what is produced and how. We've learned a great deal about how concentration across firms not only exacerbates wage inequality, but also distorts macroeconomic outcomes. Early on, we funded a report by Jonathan Baker and a literature review by Fiona Scott Morton, both of whom are co-authors of today's report. A number of studies find the markups, the difference between the price and cost of a product or service, have increased dramatically. Other studies find that concentration across industries has increased, while others find that monopsony power, that is a single seller, is increasingly prevalent across labor markets. This means that the buyer of the worker's time has undue power. And certainly there's dispute and debate about these empirical findings and what they mean. That's what academic inquiry is all about. Indeed, we hosted a panel featuring Fiona as well as Nancy Rose, who's also a co-author of today's report, to discuss the findings, critiques, and implications of the studies on rising markups. But this isn't all the evidence we have. Studies from the field of industrial organization offer little comfort about the state of competition in the United States today. To take one industry, multiple studies find that hospital consolidation increases prices and does not improve quality. When it comes to dialysis clinics, for example, scholars have found that mergers lead to both higher prices and worse quality. In other words, patients pay more, but they're not more likely to live longer. Other studies find anti-competitive effects of mergers within the airline industry, beer production, the seed industry, and even home building. Recent studies also find conduct such as predation and vertical restraints can be anti-competitive, rejecting the Chicago school belief that they are invariably benign or beneficial. When you look at the emerging empirical evidence from top scholars around the country, it's clear that greater market power is a serious threat to economic prosperity and growth. It means consumers pay higher prices for the goods and services they need. It means workers receive lower wages than if the labor markets were more competitive and where power was more evenly balanced. It means small businesses face greater challenges succeeding. And it means that innovation is stifled. And of course, there's evidence that all of this is hampering investment more broadly. Because market power benefits the few at the expense of the many, it exacerbates wealth inequality. And of course, people of color are far more likely to be victims of market power than beneficiaries of it. And they are the least able to avoid its effects. This is not a race-neutral policy. So the growth of market power also compounds structural racism and other inequities. Absent change, all of these dynamics are more likely to get worse rather than better. Think about the impact of the coronavirus crisis that we're all facing today. We know that it has hit small businesses especially hard, and in particular, local retailers and local restaurants. But large internet platforms like Amazon and Google are not only surviving, they're thriving. Uber Eats, which now generates more revenue than its ride-hailing division, and Instacart, whose valuation doubled this year to $17.7 billion, are the winners in the COVID-19 economy. But at what cost to consumers, delivery workers, small restaurants, and local grocery stores? It should come as no surprise to anyone that this COVID-19 year is likely to contribute to the market power problem, not only for 2020, but perhaps for years or decades to come. And that is one of the reasons why I think today's event and this conversation is so absolutely urgent and important. We have to get market structure right in order to make room, especially for small businesses and entrepreneurs. So why has antitrust been failing? Well, we can start with the courts that too often have embraced a non-interventionist policy that permits rather than condemns anti-competitive consolidation and conduct. One example from 1984, AT&T settled the Department of Justice's antitrust case and agreed to a structural break. In the intervening 3.5 decades, the Supreme Court has narrowed the scope of antitrust laws, particularly their application in regulated industries like telecommunication and dominant firm conduct that harms competitors. Under today's standard, the government would have a much more difficult time arguing that AT&T had broken the law. At the same time, the courts have made it harder for the government to win antitrust cases. Congress has limited the resources provided to the federal antitrust enforcers. So let me, or rather let Raksha, show you a figure. This first figure that she's going to show, hold on, now I've lost, shows that between 2008 and 2020, the economy has grown twice as fast as appropriations to the Antitrust Division and the Federal Trade Commission. Limited resources create a huge challenge for the enforcers. And going to the second figure, this one shows that between 2010 and 2019, merger filings increased over 80%, but the number of enforcement actions was flat. This is because of this is due to a lack of resources. Thank you, Raksha. So this brings us to the report we are releasing today and to our two rockstar panels. Our first panel focuses on deterrence. Enforcers, as I just noted, have limited resources. They face very well-funded opponents, and they often try cases before skeptical judges. As the panel will discuss in more detail, the authors recommend that the president appoint leaders who understand that market power is a systemic problem, are willing to implement an affirmative agenda to attack specific problems, and are willing to limit, modify, or overturn bad legal rules. The panelists will also discuss the need for more resources for the antitrust enforcers, to the tune of about $600 million, to expand the agencies so they can bring more enforcement actions. The second panel will discuss two related issues. First, the panelists will examine what Congress can do to make competition a government-wide policy, to the creation of a White House Office of Competition Policy, and the use of competition rulemaking by the FTC. So this is the kind of major reform to the antitrust laws alongside more technical ones that the panel will discuss. Regulatory agencies from the Department of Agriculture to the Food and Drug Administration to many others set the rules that affect competition. Too often, however, they miss opportunities to improve opportunities or ignore how their rules will undermine competition. The authors of the report argue that a White House office could help the regulatory agencies improve their rulemaking and to work better with the FTC. So I am very eager to hear the insights of the panelists, the lively discussion that I'm sure will ensue. The authors have done such hard work putting together their ideas, and I look forward to hearing from them. But before I hand off the Zoom controls, I want to, like Michael did, give a real big special shout out to the Equitable Growth team for all of their work in organizing this event, for organizing this great lineup, and for producing the report released today. I also want to thank all the authors of the report and the panelists. It is just an honor to be able to work with you all. We learned so much from you, and we're very eager to hear you debate and discuss your views. So I'm going to turn the microphone over now to Bill Baer, who's going to moderate the first panel.
Heather, thank you. And on behalf of the co-authors of the report, we want to express our appreciation to you, to Michael Case, and the Washington Center for Equitable Growth for the opportunity to work together to prepare this report. It has been a true privilege for us all. As Heather said, I'm Bill Baer. I'm currently on leave as a visiting fellow at the Brookings Institution to work on some other things, and it's important for me to say, because I'm working on some other things, that the views here I express are my own and not necessarily those of anyone else. So Heather described what it is we hope to accomplish in panel one. We want to focus on that part of the report that addresses how antitrust agencies can optimize deterrence and how to use existing authorities to do more and, frankly, to do it better. So 3 of our co-authors will present first, and then we're going to have 2 expert commentators. Let me, after that, we're going to invite some back and forth among the 5, 6 of us, and also give an opportunity for those of you with us virtually to ask some questions. So our co-authors, let me introduce them. First is Nancy L. Rose, the Charles P. Kindleberger professor of applied economics at MIT and a former colleague of mine at the Justice Department. Our second speaker is Jonathan B. Baker, research professor of law at American University's Washington College of Law. John and I had a chance to work together at the FTC some years ago. Third, somebody you've heard from already, Michael Katis, Director for Markets and Competition Policy at the Washington Center for Equitable Growth, and who picked this date because we all will be able to celebrate his birthday. Michael and I also work together at the Federal Trade Commission. After they present, we're going to hear from Daniel Crane, the Frederick Paul Firth Professor of Law at the University of Michigan Law School, and then Mark Anu, a Federal Trade Commission attorney who's been detailed to serve as counsel for the minority on the U.S. Senate Subcommittee on Antitrust, Competition Policy, and Consumer Rights of the Senate Judiciary Committee. So to get this kicked off, let me first ask Nancy to address some of the aspects of the report that she thinks most important to highlight for those of us participating in today's conference.
Thanks, Bill, and thanks to the Center for Equitable Growth and to Heather for a really tremendous introduction to the to today's remarks and discussion and the report. So I thought I'd start by amplifying a bit of the setup that Heather provided, and in particular, making the point, as we do in the report, that market power with its adverse consequences for the economy and for economic growth is pervasive in the US today. And we see that through a variety of ways. I'm an industrial organization economist, so I tend to like the empirical work that comes out of very detailed industry-specific studies. And findings from a broad empirical literature show that mergers in recent decades have been disproportionately associated with price increases or quality decreases for consumers. And emerging evidence suggests with lower prices and wages for suppliers or workers at merging firms. Avoiding these harms ought to be low-hanging fruit, preventing consolidation and encouraging firms to outcompete each other for new business and growth advantages everybody but monopolists. And yet these costs are ubiquitous and large. As Heather's introductory remarks discussed, research on healthcare, 18% of US GDP, exemplifies this conclusion. Prices are higher, quality is no higher and seems to be modestly lower on some dimensions, and wages for affected healthcare workers are lower, all because of anti-competitive mergers that have taken place in this sector. But it's far from confined to healthcare. While many of these studies focus on unilateral effects, as do many merger cases, emerging evidence suggests that mergers may also facilitate tacit collusion or coordination. An example of this is Nate Miller and Matt Weinstein's analysis of tacit collusion following the Miller-Coors joint venture, and recent work that suggests that airlines may be more effectively tacitly coordinating capacity or pricing in the wake of substantial merger consolidation. Increasing research shows that mergers may be motivated by a desire to eliminate competitors or competitive threats, the kinds of killer acquisitions or stealth consolidation that Heather mentioned, in an attitude of keep your friends close, but your rivals closer. And of course, those are an ongoing concern in the digital economy. But it's not just mergers. Anti-competitive conduct harms consumers and markets, and that was very amply highlighted by the various House subcommittee hearings this year and the reports that came out of that, which highlighted a wide range of conduct concerns in the digital economy and adverse implications for competition. Again, the problems are far from confined to tech, even if that provides an easy example to point to. To highlight a few recent ones, the DOJ District Court record proved substantial adverse impact from Amex, American Express anti-steering contracts, yet the Supreme Court majority brushed those away. Anti-steering, most favored nations clauses, and other anti-competitive behavior has become common among dominant firms. In generic drugs, ongoing pay for delay and product hopping seems to be increasingly a game of whack-a-mole, where firms adapt agreements in an effort to avoid both competition and antitrust enforcement. And algorithmic collusion, that is tacit collusion facilitated by artificial intelligence programs, has been an area that's been discussed in theory for a number of years, but recent empirical work is suggesting that it's already happening. There's a recent study on German gasoline station data that suggests substantial pricing impacts from companies that adopt these programs. So why is this a problem? Why do we see this happening? Well, antitrust is at heart a deterrence-based system. And I fear it no longer is up to the job of maintaining the free and fair competition that's vital to a well-functioning market. To expand on Heather's remarks on enforcement, the merger guidelines over 40 years have repeatedly raised the level of concentration that would flag mergers as highly concentrating. And yet courts and sometimes enforcers appear to raise the threshold of concern still higher. It's increasingly difficult to hold the line without costly litigation, sometimes even at 3-to-2 mergers. Companies come into the agencies with mergers to monopoly or duopoly, or others that should never have left the boardroom, in the words of a recent enforcer. And DOJ and the FTC have to spend months in investigation and months more preparing for litigation to block them. Companies appear to consider this the price of the lottery ticket for a chance to get an anti-competitive merger through. Similarly, exclusionary behavior to raise rivals' costs, discourage their entry into markets, exclude them from customer access is very rarely challenged in the US. And when it is, the courts are disinclined to support those challenges, invoking outmoded, irrelevant, or specious economic reasoning in many cases. And even legal success may be just a slap on the hand and an agreement not to do it in the future, not an outcome designed to deter. When companies recognize that they can buy, bully, or foreclose competitors, or collude with the few remaining competitors who may be their equal, there's little incentive for them to compete on the merits. When the antitrust sheriffs are outstaffed, outgunned, or hobbled by overly skeptical courts, that behavior increasingly becomes the norm. And when too often courts retreat to economic platitudes about the efficiency of unfettered markets and the cost of false positives, unaware or unwilling to consider the impact of inaction on damaging those markets, we find ourselves where we are today. That's why we're recommending the incoming administration pay particular attention to appointing agency leaders who are experienced, committed, and capable of pursuing a strategic and targeted pro-enforcement agenda. While enforcers alone are unlikely to restore a vibrant competitive economy overnight, much can be gained and must be attempted by a strategic and proactive agenda that identifies focused targets of harm, communicates those harm and their consequences not only to the business and antitrust communities, but to the judiciary and the public, initiates enforcement actions to signal intolerance of anti-competitive behavior and intent to pursue enforcement actions against it, and persists even in the wake of expectedly
Nancy seems to have frozen a second.
Oh.
Nancy, can you keep going?
Sorry, where did it stop?
We just missed a sentence and a half.
Oh, well, I just said I look forward to the remaining discussion, which I think will flesh out what what we mean by this in more detail.
Thank you so much. That was an important part of your remarks, but probably the least important at the end of the day. Next, let's ask John Baker to talk a little bit about the challenges of the new leadership is going to face, how they're going to address those challenges, the extent to which current legal jurisprudence can be used to advance some of the aims that that Heather and Nancy have talked about. John?
Thank you, Bill, and I'm delighted to be here. The predicate for what I want to talk about is what Nancy said, that we need to strengthen antitrust to increase deterrence of market power, which is a growing problem in the economy. And I want to just think about the courts for my few minutes with you and put aside legislative responses, which are going to be the topic of the next panel. But just thinking about the courts, the new enforcement leadership face what seems to be a novel and large, substantial challenge to do more while operating in a difficult judicial environment. So there are some parallels from the past, but the problem is more difficult today. So the Reagan administration's team wanted to change the focus of antitrust enforcement too, but their job was easier. They wanted to narrow its scope, which they could do in part by choosing not to challenge various cases. And they had a Supreme Court that was receptive to their view of where antitrust law should move the lines, in determining what harms competition. The challenge that was faced by Thurman Arnold in 1938 is a closer parallel because Arnold wanted to ramp up antitrust enforcement, but doing so is harder today than for him because, with Arnold, the Supreme Court was sympathetic to what he wanted to do. Now, our report emphasizes that increasing deterrence of anti-competitive conduct, the enforcement agencies, in addressing this uphill challenge, they need to think strategically about priorities, particularly in case selection and in choosing what amicus opportunities to pursue, but also in setting out guidance and giving speeches. And when setting an agenda, the agencies could identify targets in several ways that aren't mutually exclusive. They could look for industries with market power problems, which is what Thurman Arnold did. They could look for types of harm that haven't gotten the attention they deserve, perhaps harm to workers or the disadvantaged, or practices, perhaps things like platform most favored nations provisions. They could look for legal doctrines that insufficiently deter harmful conduct, which are, and those are also areas for legislative correction, which the next panel may address. And if the enforcement agencies target areas like these, to strengthen deterrence of anti-competitive conduct, they're going to have to win cases in court. That's not entirely a hopeless prospect under current law. Enforcers do still win cases, particularly when they uncover strong facts. So just for example, I was looking at the Justice Department and Federal Trade Commission's exclusionary conduct cases that went to the appeals courts during the past 2 decades. And the government won a few, Microsoft, Visa, Dentsply, and McWane. They lost some other cases, AMR, which was the American Airlines predatory pricing case, and Qualcomm. But still, there has been some success, and there's case law on which to build. In horizontal merger review, thinking of now of the case law, over time, the courts have accepted unilateral effects analysis. And they've accepted the idea that the loss of a maverick in an industry conducive to coordination makes coordinated effects more likely or more effective. And the agencies encouraged those developments in merger law through successive revisions to the horizontal merger guidelines, which are often treated as persuasive authority by generalist judges. In other words, and then the enforcement agencies in the new administration may be able to make progress in increasing deterrence using the courts. They'll need to look systematically at the economy to identify industries where they can make a difference, the types of harm that need more enforcement attention, the areas of doctrine where the error cost balance reflects a skewed view that's skewed toward insufficient deterrence. And they'll need to push the courts to correct these problems even without legislative intervention, through an integrated approach, as Nancy pointed out, involving enforcement actions, amicus briefs, policy guidance, and a range of tools. And I'll just stop here and let Michael pick up the thread.
Thank you, Jonathan. I think part of what, as a group, we confronted in preparing this report was to think about what could be done in the face of a judiciary that has largely adopted a fairly cautious Chicago school approach. And I think you do a nice job of indicating some areas where progress has been made, and there are opportunities to pursue an enforcement-minded agenda. Let me turn next to Michael to offer his views on particularly important aspects of the report. And Michael, I think at the end, if you wouldn't mind spending a little time talking about this issue that Heather raised and that you've written about regarding the need for more funding in order for the 2 antitrust agencies to do their job. And happy birthday.
Thank you, Bill. And I'm sure the president is on the way from Amazon Direct as we speak.
You bet.
Or preferably not Amazon Direct. So no, thank you. What I want to sort of do in my time is sort of drill down a little bit from where um, Jonathan ended up, which I think provides a really strong overview for what we were thinking about. And where, I think it's important as I see this report is really about how to get better results in antitrust enforcement. And we all spent time in government. And I do not see this report as us saying when we were in government, everything worked fine, it was all great, and you should just do what we did. I think what it is a reflection of people thinking back to what worked and didn't work, and trying to figure out how it can be done better the next time. And I think it's really important. I've learned this from my judge, who, whenever I apologized for any mistake, he'd look at me and say, "Michael, I made 10 mistakes before I poured my first cup of coffee this morning. Don't apologize, recognize the mistake, and then just try to learn from it." And so I want to start with two sort of specific examples when we think about government enforcement over the last 20 years. One that I think was largely a success. One that's largely was unsuccessful. And they both involved the FTC, and they both involved while I was working for the John Leibowitz. So like, I'm part of the solution, part of the problem. I'm not criticizing anyone else. So the first I want to talk about is the patent settlement situation, which began late in the 90s when Bill was still bureau director. We started seeing that branded companies were paying their generic competitors as part of patent settlements to stay out of the market for some period of time. We all thought that this was obviously anti-competitive and that this would kind of, we'd bring a couple cases and we'd be done with it. Instead, the appellate courts had a very different view. They thought these were the greatest things since sliced bread, and thought that the right rule was one of close to per se legality. And the commission didn't walk away from those defeats. A series of chairpeople, both Republican and Democrat, dug in and kept fighting on this. And we ended up, and then when John Leibowitz became chairman, what he really did was to build on that agenda. Was he really tried to leverage the entire agency's resources to attack the problem. And so that meant really leaning on the economists at the agency to study the problem more. Policy people issued reports. We continued to pursue cases. We considered bigger bank shots, whether rulemaking was a better way to go than litigation. We worked with the Department of Justice, and it became part of the communication plan. And so there was a lot of communication, not just to the bar, but in the popular press, on Congress, so that people understood why why the agency didn't withdraw. And that was important to maintain support for what we're doing. And eventually the Supreme Court successfully issued a decision that rejected the existing rule, and we've seen a dramatic decrease in the types of problematic settlements. So that was a success. Let's talk about the other big priority that we talked about in the Obama administration at the FTC was using the FTC Section 5 authority to go after things that were unfair methods of competition, but not illegal under the Sherman Act. And people sort of forget, way back in 2000, when John was a commissioner, he was talking about this, and there were some consents, but you look back and there's not a lot to show after the fact. And so why was that? And I think part of that was that there wasn't that same sort of intentional view of identifying the problem and figuring out how to attack it. It was really sort of much more waiting for the right case to come along. And to be honest, that is to move the law, to attack these problems, you have to be more proactive. You have to identify the problem, and you have to think about how to attack it. And it's okay to bring cases and lose, and sometimes even bringing cases has a deterrent effect. But if you just bring cases without a plan and lose, you're just making the situation worse. And so from my perspective, this is really what you want out of antitrust enforcers. And it starts with the people who are appointed. And you need people who both understand that we face a dramatic problem, that this isn't about waiting for the complaints to come through the door, and who have no qualms about pushing and being aggressive, but also who have the experience and the ability to manage those agencies and leverage those resources. This is particularly true if the law doesn't change and the appropriations don't change. Because in that world, the only thing we have, the only level we can affect is how the agencies enforce the law. And so I'm going to move on to the Bill's, I guess we'll call this Bill's first question on the appropriations. So the report recommends an increase in resources for antitrust enforcement, $600 million, which we roughly estimate is about, they're currently somewhere around 200 million. And so Raksha, I'm going to go back. If you could just show the third chart, since I think that just move along because Heather did a perfect job on the first two. And so I want to talk about why we came up with that, how we came up with that number. And it was, if we look at total civil antitrust enforcement actions over, the last 2 decades, look, there are variations from year to year, and I think those reflect enforcement priorities and prosecutorial discretion, but you're basically pretty much between 35 and 55. And, and the question is, at current appropriation levels, that's probably going to fall because it's just hard to see the agencies able to maintain their current level when the appropriations themselves are flat or slowly increasing. So you start with the fact that that's where we are. You start with the fact that this doesn't reflect, and then when you add to that, if you agree there's a big monopoly market power problem in the economy, it can't be that this is the right level of enforcement. And yet this is, I think it's fair to say this is where reflects pretty much where their capacity is. So part of this reflects, if you got a big problem, you got to have a big army to go after it. So roughly we're saying if you double the budget, you have the capacity to double enforcement, and you got plenty of targets to go after in this economy, and you need the troops to do it. But it also, the idea is also it increases the agency's abilities to study problems, to do merger retrospectives without that slowing down enforcement. But those sorts of studies after the fact of what happened in mergers, they are very expensive and time consuming. And also to deal with the suggestions in the report that we think that the FTC, for example, needs to use its rulemaking authority to address unfair methods of competition. So Bill, that just as question, that was sort of, I think, why we think, why we came up with the number. I'm fairly comfortable saying I don't think you get effective enforcement with much less of a number. You could probably convince me to increase that even more. But that's sort of why we thought it was important to talk about appropriations, because the agencies really are sort of at their budget limit. And one of the nice things for me, I guess, is when I first started Equitable Growth, this was really the first issue I talked about, and I got hit hard from the right because I was wasting taxpayer money. And then, but people on the left also hit because they were like, can't give the agencies any more money because they will waste it. But what I've seen in the last couple of months is on both the right and the left, everyone seems to recognize that we're not spending enough on antitrust enforcement.
Great. Thank you, Michael. I should add, although we don't have a chart on this, the report does also talk about cartel enforcement and the dramatic decrease we've seen in cartel enforcement from the Obama years to the current president's record. We've gone from about an average of 60 cases, criminal cases per year in the Obama years to about 23 under Trump. And if you look at corporate accountability, charges against corporations, we've gone from about an average of 20 a year under Obama to just about 8 under the Trump administration. So there are issues there that that need to be addressed, that enforcement needs to go at. All right, so let's turn to our first commentator, who by using a virtual background leaves us no doubt about where he is teaching law. Dan, you're free to praise this report up and down, but and we did give you an advanced peek a little bit at where we're going, but in the event you feel the need to disagree with anything reluctantly, we're going to give you that opportunity. Go ahead.
Well, thanks very much, Bill, and thanks, Michael, for inviting me to be on this program. Happy birthday. I will let you know for sure that my gift to you will be coming from our mutual friends at Amazon, since we both share such affection for that company. So as Bill said, like I was invited here to be the reactionary on the panel, and I'll try not to disappoint, but there's so much in this report I actually agree with that I'm also going to try to be constructive, because again, I think moving forward, the point is not about looking back, it's about looking forward. So I want to make two broad points. One is about avoiding overstatement, and the other is about avoiding understatement. First, on overstatement, I think there's a tendency in lots of the recent discourse to overstate the extent of the antitrust system's failure in recent decades, and also the degree to which this has resulted in an uncompetitive economy. So I read in the report that antitrust enforcement has been stagnant or declined for many years, contributing to today's market power problems, that the agencies have been risk averse in case selection and failed to adopt an assertive enforcement agenda. Heather said in her introductory remarks that antitrust enforcement has been failing us. So I was wondering, like, that wasn't me. I wasn't involved in antitrust enforcement. Who's to blame for this? And then I looked at the authors of this report, and every single one of you was a senior antitrust official in the last couple of decades. And so I want to know, is this a confessional? And my point is, like, don't be so hard on yourselves. I think actually you did a pretty good job. Cheer up. I mean, I think things are not as bad as you suggest in the report. The narrative just needs to be a lot more nuanced than antitrust enforcement is broken. We have made a tremendous amount of progress on many fronts in antitrust enforcement in the last few decades. So Bill mentioned the issue of cartel enforcement. So let's talk about that for a minute. The report, as he says, criticizes the Trump administration for laxity in anti-cartel enforcement. But let's just take an overall look at where cartel enforcement has been in the last several decades. Well, first of all, beginning in the Clinton administration, really, and moving forward through the Bush administration and the Obama administration, cartel enforcement reached a level that it had never been at historically. If you look at fine levels, if you look at conviction levels and prosecution levels, this was a golden era of antitrust enforcement against cartels. Now, how did that happen? It happened due to the magic of leniency and amnesty programs. That's what brought the cases to the DOJ's doorstep. And this was a good thing, right? Companies were bending over backwards, were racing to get their place in line in order to cooperate. The problem was that the super tool of leniency also had an expiration date. And that was because as more countries around the globe started enforcing the antitrust laws themselves against cartels, had their own leniency programs that often weren't coordinated with other leniency programs around the world, and companies that were getting some degree of leniency from DOJ or the European Commission were still finding themselves hit with enormous damages awards or settlements in private cases. At a certain point, leniency applications started to dry up. And when the Trump administration came in, I'm not part of it, I'm not here to defend it, but just as a fact, when the Trump administration came in, leniency applications had already dried up. And by that time, the DOJ had kind of lost the old-fashioned shoe leather approach to antitrust enforcement that it had for many years. It sort of had been so reliant on leniency applications that sort of turning that ship around and starting to work on sort of the old-fashioned investigation and shoe leather approach just was going to take a really long time, right? So what's the moral from this story? Is it that someone's to blame? Like, I don't think anyone's to blame for this. It's sort of an explanation about where we got on cartel enforcement, why we're there, and of course this calls for rethinking, reimagining, incremental adaptation, figuring out how to get leniency back in the picture again, figuring out how to hit international cartels again, which are not coming to our doorstep to apply for leniency. Like there's lots that we need to talk about. But the narrative can't simply be about failure and about blaming any particular administration for laxity here. The question is, going forward, how can we do better? How can we learn? And I would say that's true. That's true of merger policy. That's true of civil non-merger investigations as well. That's true of private enforcement. That's true across the board. Another caution in terms of overstatement relates to this sort of narrative that the U.S. economy is, as the report says in its opening line, plagued by excessive market power. Elsewhere in the report, we hear that there's growing market power across the United States. Now, no doubt, there are sectors of the economy, there are markets that have become significantly less competitive, because perhaps in many cases because of insufficient antitrust enforcement. But call me a denier, but I think it's hard to sustain the claim that across the economy as a whole, there is, in John Baker's words, a paroxysm of market power that's just sweeping across everything. If we look at the last 2 or 3 decades and compare where we are today in many industries to where we were 2 or 3 decades ago, you will find that we are much better off today in many industries. So I'm from Michigan. I do a lot of work in the car industry. By any measure, the US car industry, the international car industry is much more innovative, dynamic, and competitive today than it's been at any time since the introduction of the internal combustion engine. Right? We have new entrants across the board. We have technological dynamism and innovation in that industry. It's a much more competitive industry than it was at any time before the last 20 or 30 years, right? And that's one industry accounting for about 4% of GDP. And we could go back and forth, right? I could talk about rocket launch. You could talk about airlines. We could go back and forth and compare industries. But that's my point. This is not an economy-wide problem. It is a market-specific problem. And to recognize that fact is really important to understanding the implications for legislation, reform, funding, and targeted enforcement going forward. One more point on overstatement concerns, something that's in the report, and Heather also mentioned this in her opening remarks. It relates to antitrust and wealth inequality, something that John Baker and I have debated at length before, but also in particular about antitrust and its effects on historically disadvantaged groups and racial minorities. So very clearly, there are important ways that we should care about in which the exercise of market power disproportionately harms people at the lower strata of society in terms of income or traditionally disadvantaged populations. But it's also very clear that the effects are complex and cross-cutting, and that there are other instances in which more aggressive antitrust enforcement would not particularly help, may actually hurt disadvantaged populations. I call to your attention, just for one example, the Att T-Mobile merger that John Baker and some others had a part in stopping in 2011, which I think was quite appropriately stopped on market power grounds. That merger was supported by the NAACP, the Gay and Lesbian Alliance Against Defamation, the National Education Association, the Columbia Urban League, and the 3 million member strong Telecommunications Workers Union. All those public interest organizations thought the merger was good for their constituents. It was good for racial minorities. It was good for unionized telecom workers. Now, they may have been wrong about that, but the point is that you cannot simply have a narrative where if we amp up antitrust enforcement, it's all good for all segments of society that we want to protect, right? That is not true. There are many examples when there are important trade-offs that have to be made between different kinds of constituencies that are affected in different ways by more or less or different theories of antitrust enforcement. The other point I wanted to make, and I'll end on this, has to do with understatement. In particular, the fact that lots of the current rhetoric around antitrust reform and criticism of antitrust enforcement since the rise of the Chicago School has a tendency to forget that there was a time in American history where we really overdid it in the opposite direction. So a little over a decade ago, a number of the authors of this report also contributed to the late Bob Potofsky's book, How the Chicago School Overshot the Mark. And that book, quite wisely, I think, began by acknowledging that the Chicago School was not simply doing polemics against straw people, that there was a real problem of over enforcement and the wrong kind of enforcement that was being responded to. Let's not forget the Vaughn's Grocery case, where the Supreme Court condemned a merger to an 8% market share in a very, very unconcentrated industry. Or the Utah pie case, where a company with a 60% market share in frozen pies successfully complained that it had to lower its prices because a competitor was lowering its prices. Or the Procter & Gamble and Brown Shoe decisions, where the Supreme Court suggested that efficiencies might count against a merger. Or United Shoe, where the district court condemned a company as a monopolist for offering customers financial incentives to renew their leases, right? Ordinary commercial and pro-competitive behavior, right? And we could talk through many, many other cases where the courts condemned price cutting, efficiency, innovation, and good old-fashioned competition. So those are not made up stories that really happened. And I appreciate that this report says the focus needs to be on going forward rather than going back. As we talk about antitrust reform, let's make sure that we don't forget the very real danger of overcompensating or overcorrecting. That's not a law school hypothetical. That's our not too distant history. Thanks.
Dan, thank you. As usual, you did not disappoint. We really appreciate it. Next up is Mark Liu. Mark, as I said at the introduction, he's currently on the Hill working on minority staff of the Antitrust Subcommittee of Senate Judiciary, but he's also had experience in the private sector and is on detail from the Federal Trade Commission, where he's got some considerable experience. Mark, we welcome your interjection.
Thanks a lot, Bill. Hi, everyone. First of all, I want to thank Heather, Michael, happy birthday, and the entire team at the Washington Center for Equitable Growth. I've always found the center's programs very insightful, and it's a pleasure to be able to participate in this discussion on this very important topic. First thing, a few preliminaries. I have to make a double disclaimer, as Bill mentioned. I have two masters, but I'm speaking here on my own behalf, and all the opinions I share are my own. I'm not speaking on behalf of the Federal Trade Commission or any individual commissioner, and I'm also not speaking on behalf of the Senate Judiciary Committee or any of its members. My initial reaction to the report is I agree with almost all of what's in there. I think the report's a timely and important contribution to the debate on where antitrust enforcement should be headed. Even if not everyone is going to agree with the recommendations, I think it should be almost required reading for future agency leadership. They'd be well served to read the report and to consider what it has to say. Now, it's true that the antitrust agencies are limited in what they can do to improve enforcement and increase deterrence. They're enforcers, not lawmakers, and they're bound by precedent and limited by agency resources. And that's a fact that's not going to change even if the agency budgets are increased. Enforcers are always going to have to make hard choices about what their priorities are. But the fact remains that I'm in agreement with the report's view that our country is facing a monopoly power problem, and revitalizing antitrust enforcement is a necessary part of confronting the problem. I mean, it doesn't mean going back to Vaughn's Grocery, but the pendulum needs to swing back in the other direction. So from where I'm currently sitting as a Senate staffer, I have a firsthand view of some of the competition policy debates that are taking place on the Hill, and there seems to be a growing acceptance that more needs to be done, and that Congress should consider revisiting antitrust. And that includes reform to substantive antitrust laws. It includes reform to antitrust procedures and reforms to the institutions themselves. A number of serious proposals have already been introduced in Congress, and I expect these debates are going to continue well into the next Congress. I don't want to say too much about legislation given my role, and of course, the next panel is going to be discussing those types of issues in depth. There does seem to be a desire in Congress to see more robust antitrust enforcement as a general matter. And if that desire isn't universally shared, it's my sense that it's at least bipartisan. So we're not just talking about one party here. On the report itself, I think it presents an effective roadmap for what I think federal enforcement could and should look like in the next administration. So I have a few thoughts on the report and some of the things in it. First, on agency leadership, a big part of the report talks about the importance of appointing the right leaders as a necessary first step. And the authors have identified the qualities that many of us would like to see in leadership at the antitrust agencies or in fact, in any agency. But I'd like to focus on the importance of a long-term vision for forward-leaning enforcement. The new leadership is going to need to make an affirmative case that existing legal tools can and should be used more aggressively than they currently are. And that's a long-term project. But there's a broad spectrum of pro-enforcement opinion, and not everyone who wants to see more enforcement agrees on what should be done. What some may see as bold changes, others may view as far too incremental. These are debates that folks are having on the Hill on a daily basis. So I think it might be important to select leaders that have a shared vision on competition policy and enforcement, or at least compatible visions. Given the recent conflicts between the agencies and the current administration, it would be helpful to have leaders at the DOJ and the FTC that are willing or even eager to collaborate, not just on enforcement, but on the longer term project of steering the law in a positive direction to protect competition. The report also recommended the creation of a White House Competition Policy Office. I personally think that's a good idea. Having the White House office providing competition-focused oversight over the regulatory process would be particularly valuable, especially if Congress gets around to passing comprehensive federal privacy reform that calls for rulemaking. That's an area where we can expect to see tension between competition and regulatory goals, but of course it's not just privacy. There are a host of regulatory rules that affect competition, and having competition-focused oversight from the very top could be essential to striking the right balance. But I think, again, the effectiveness of such an office is going to drive positive change, is actually going to be greater if it's staffed by people who share a coherent pro-enforcement vision that's compatible with that of political agency leadership. A little bit on the recommendations on driving deterrence. Many would like to see the antitrust agencies be more aggressive in bringing more difficult cases and advancing novel theories to push the law forward. Some want to see more vigorous approaches relating to potential competition or innovation-based effects. I think Nancy had mentioned algorithmic competition and other theories of harm. Others would like to see the FTC consider an expanded use of Section 5. Although the report doesn't explicitly mention Section 5, it seems implicit in the call for potential FTC rulemaking. And there are, of course, potential sensitivities given the history of the use of Section 5, how it was used in the 70s and the backlash that resulted from that. So it's an area where the agencies need to be, or rather the FTC needs to be very thoughtful of its approach. And I think one of the strengths of the report is its focus not only on goals, but on actual implementation. More calculated risk-taking in bringing difficult cases and FTC rulemaking should be supported by an investment in bolstering agency staff and building a factual predicate by commissioning competition studies in key industries of concern. I think there is potentially great benefit in the FTC conducting more 6B studies in supporting and justifying FTC rulemaking, and also informing potential legislative action. These are things that people pay attention to on the Hill. 6B Power is a powerful tool to focus on industries that suffer from market power problems. And in this respect, I think our enforcers suffer in comparison to enforcers in other countries. One example is in the digital platform space. In the Senate, as you can imagine, we spent a lot of time considering competition issues raised by digital platforms. But over the last couple of years, we've had to refer to industry competition reports from Europe and United Kingdom and Australia. For US information, we've had helpful reports from academic institutions like the Stigler Center report, but of course those institutions lack subpoena power and the ability to compel witness testimony. The recently released House Digital Markets report, which, where the staff has those powers, has also been really helpful, but the House Judiciary Committee is a political body. It's not a law enforcement institution. A 6B study on some of these digital markets could have been helpful to the extent such studies can be issued without interfering with potential or impending enforcement action. They might still be helpful. But of course, there are a lot of other sectors. It's not just digital platforms, and the FTC has the authority to look at those under its 6B authority. There are many topics that could explore, including retrospectives on labor market effects, but not just retrospectives. But as an example, the European enforcers have sector inquiries. Doing that kind of broad-based investigation can be helpful in driving progress and also in advancing the thought on a lot of these issues. But the point is that FTC rulemaking should be supported by studies like that and other types of evidence. There are a lot of people in Congress and in the antitrust community who remain skeptical of FTC rulemaking. So I think the report's advice to the Commission to do its homework to support any rulemaking is extremely important. I personally agree the agency should consider competition-based rulemaking. And as the report points out, the authority hasn't been used in 50 years. But there are recent proposals floating around the Hill that would undermine the authority to conduct those rulemakings. So it actually might be a really good time to show how useful that process can be. Of course, I want to be clear, I'm not criticizing the FTC for prioritizing actual enforcement over 6B studies. That's a very reasonable choice to make. But there is, as Michael discussed and is in the report, a well-documented shortage of funds at both agencies. And that leads me to wonder, which and how many of the report's recommendations can be implemented without a substantial increase in agency resources. Of course, there's a lot that can be done, but I'd be interested in hearing from the authors what they think could happen without $600 million or perhaps a more modest amount. One last thing, the report makes the point that the agencies should prioritize communicating with the public, and I absolutely agree with that. The public has never been more interested in antitrust issues than they are now, and the agencies are in a unique position to help bridge the gap between the antitrust community, policy advocates, and the general public. Those of you who work in the field know the reaction that you get when you describe your job to people now is probably different than it was 5 years ago. It takes a few extra minutes for the eyes to glaze over. So I think that's an important point that the report made. My view is that communication like that is key to reestablishing a broad and enduring antitrust consensus that's driven by a shared understanding that competition is a key pillar of our capitalist system and our society, and that more vigorous antitrust enforcement is needed to protect that. So with that, I'll stop there and look forward to the discussion.
Mark, thank you so much. Before I ask our co-authors whether they want to respond, I just want to reiterate what is appearing, I think, on everybody's screen, that at the last 15 minutes, we hope to be able to pose questions that you, the virtual audience, have. And as I understand it, you do that to the Q&A box, and then they'll be filtered up to me to pass on. But having heard some thoughtful commentary from Dan and from Mark, let me ask whether Nancy, Michael, Jonathan, are there any particular points you want to respond to? John.
There I am, unmuted, good. Thank you, Dan and Mark, that was very interesting. There are a couple of things that Dan said that I'd like to address. I thought Dan, that your big argument misses the forest for the trees, that essentially you focus on anecdotes and lose sight of what's true on average. So with respect to market power in the economy, it turns out it's been growing for decades, but in the economic research, we didn't really figure that out until last five or so years. And it's not in every industry, and I agree with you on that, but it's important enough a change in how the economy is operating to have macroeconomic effects. And so of course, if you went industry by industry, we'd find plenty of industries where there are problems, as a result. And those are the ones, of course, where the antitrust attention should focus. The same kind of issue comes up when talking about inequality. The benefits of competition, increased competition in antitrust enforcement for reducing quality are true on average. And that's because essentially that the owners of firms are wealthier on average than those who are harmed by the exercise of market power, whether it's the buyers or the input suppliers, the workers, say, or something. And that's a true on average in general. And of course we can find examples or make them up where there's a worker-owned cooperative or something that sells luxury items, and if they were to exercise market power, that would take from the rich and give to the poor or something like that. But coming up with those kinds of examples or real world analogs, doesn't detract from how things look on average, which is that that increased competition is going to help in addressing problems of inequality. And I just had one little question about the whether the leniency point that you made, which is a little different from the other things, which is I really wonder whether it was a one-time ramping up of deterrence, because on that account you'd expect that Ann Bingaman came in the 1990s with the leniency program, and deterrence increased. They brought cases, they've identified problems, deterrence increased. You'd expect the benefits of that for identifying cartels to have died off much more quickly. But it's 25 years of steady uncovering of cartels, at the Antitrust Division, and so I'm really wondering whether whether it's fair to describe what we see as finally the leniency program, petered out in its significance. So let me stop there.
Okay, other, Nancy, Michael, you want to take on any of these issues?
Go ahead, Nancy. I saw you had unmuted first.
No, I would just want to pick up this theme that both Dan and Mark alluded to, which is, what can be done without more resources, or who are we blaming, or is this somehow a mea culpa by people who served in prior administrations? And I want to say, I think all of those, and I think there's some questions that have come in as well that are linked to this. I think all of that is part of the coherent story, which is, frankly, the antitrust agencies have not had the resources to even maintain enforcement in an environment that was unchanging, given the economic growth. As I alluded to, I think deterrence is quite clearly down in a variety of areas, and that's going to increase the number of companies that are attempting anti-competitive behavior. And so if you want to both deal with what comes in front of you, anti-competitive mergers, anti-competitive conduct, collusion, you're going to need more resources to address that. And if you don't have them, Mark, honestly, my sense is you're going to be kind of on the path we've been on, which is the agencies will go after the stuff that's super time critical, like terrible mergers that get proposed, because if they do nothing to address those mergers go through and are basically impossible to undo ex post. The unscrambling the eggs is the reason we have the Hart-Scott-Rodino Act. They'll try to find time to do conduct investigations, but I think what we've seen is or collusion investigations, when things get tight, those get put on a back burner because they're not as time sensitive as mergers. And so I think if we across both sides of the aisle and in society think that we want competitive markets, which I think is a principle that we largely all used to agree to, that I think we need more resources. Now, you can quibble over how much, and as Michael said, that's going to determine, do you just deal with the worst of the mergers that come through and have a few conduct cases on top of them, or do you do more? I think there'd be a huge economic payoff to doing more. I think competition, to your point, Dan, I think competition is great. And we want to ensure that more of our economy is competitive, not less.
Michael.
Sure, I want to just touch on 2 points, and I'll try to be brief. One, on the dangers of over enforcement. I think if you are a lawyer around my age, 25, or maybe twice that.
26 now.
Yes, thank you. That concern is like injected into your DNA and was injected in your DNA in any antitrust law school class. And it was injected, it is just unavoidable in the agencies as well, at least when I started, and for a long time thereafter. Here's a question, let's take a step back. What were the real costs of over enforcement? And let's take the two examples that everyone is going to use, Vons Groceries, let's just assume that was wrong, and the price discrimination criminal prosecution of the great A&P company. Okay, last I checked, Vons Groceries happened that did not stop the profitability of grocery stores in America. It didn't lead to massively increased price of food. There was lots of innovation in the 60s with moving to brand products that were good. So even if Vons Groceries was wrong, I don't know, not really, really wasn't a big long-term impact from that piece of over enforcement. Oddly, that the other one is also the great in grocery stores, the A&P company, which was a criminal enforcement. Even as to A&P itself, it lasted for another 50 years. And the degree it didn't last has little to do, if anything, with the criminal prosecution. So if that's your weight of, this is what we have to be worried about, let's look at the other side. And I'm sure everyone on this panel is like, okay, he's going to talk about patent settlements again. No, let's look at hospital and merger enforcement. The government lost 9 cases in a row and spent a decade retooling how it was going to challenge those mergers, how it was going to deal with court after court coming up with bizarre reasons why they were losing, and eventually was successful. But that means we had a decade with no enforcement. Not a single merger was blocked in the hospital industry. And if there is one area where the IO literature is absolutely certain about the problems of consolidation, hospital. More papers than fit on one hand. So I'm a lot more worried about where we under enforce than where we over enforce. Like I'll be open about that. And I also want to say just a little bit more on the racial issue. And I think that this is an important conversation. One, antitrust community has not had. It will be, I think, challenging. And part of it starts with the fact that there isn't a lot of research here, which is part of the problem. But also, I think what at least my understanding from what we were trying to accomplish in the report is that where you start with a society where there's already racism and huge racial disparities, got to remember when we mess up policies like antitrust enforcement or environment, any policy, it's going to compound the problems that that people who are being subjected to these disparities. It makes it even worse. And so that's why I think that piece of the report is there and why it's important. And I really view this as that part of the report being about opening and having a dialogue, because this is an issue that is important across every policy area, and something that we really need to discuss.
Thanks. Dan, do you want to respond to that, particularly the notion that moving the pendulum back towards a more assertive enforcement posture doesn't mean going back to the days of Vons Groceries?
Yeah, and to be clear, I'm not saying don't change anything because you could go in the wrong direction. I mean, Mike, as I said, there's a lot in this report that I think is right, and I do think we need to rethink lots of aspects of antitrust enforcement. My point was about overstating and understating. And on understating, I didn't see a lot in here in this report or in the general narrative today that recognizes what I think everyone on this call knows is true, which is that there was a period when we enforced a lot more. And again, lots of people who contributed to this report are on the record as having acknowledged previously that there was a problem, that we overdid it. And so my point is, as we're talking about moving forward, let's make sure we're clear that we want to move forward and not go back, and not ignore what the period of American history where we did enforce in ways that I think are, at least from my perspective, indefensible.
very helpful. Let me make a quick comment on criminal enforcement, and then I think we'll go to some of the questions that are beginning to get filtered through to me. I do think Dan makes a fair point that the leniency program has of late resulted in fewer applications. And it may well be that Dan is correct that the costs associated with seeking leniency, because you may have consequences in multiple jurisdictions where the application of that policy is a little less transparent. But I also think it's quite possible that the benefits of leniency in the US in particular have been significantly reduced, at least if you're a large corporation. One of the things we note in the report is that under this administration, you can be the second or third or fourth company in, and you can put yourself in a position where you can still avoid a criminal conviction. You can pay a big fine and get a deferred prosecution agreement. So now the benefit to the first company in to self-report is greatly diminished because you've got a back door out later on in the process. That was something that I think DOJ, when the policy was first adopted, fought strenuously to avoid, to basically maximize reward for first in and not allow corporations, particularly large corporations, to avoid the consequences of coming in later. You could reduce your fine by cooperating, but you still had to pay the price. And these days, small, medium-sized businesses pay the price, and it looks like there's more opportunity for a big company to avoid that criminal conviction. But let me go to the questions here that are coming in. Our friend Zephyr Teachout, Fordham Law professor, has a question that I'm trying to get to here. She testified before the Cicilline subcommittee on October 1, and her question is, comment, I think, to provoke a response. The focus on mergers in the report suggests you don't see a real issue with the existing monopolists. The contrast between this and the Cicilline report is quite stark. What do you propose for existing behemoths? Anyone want to take that on?
I guess I'll defer, but figuring in the time that it took me to figure out how to unmute my camera 9 months after the pandemic was enough time. But we talk about a lot of what the report talks about. Has a section talking about the failure to do merger enforcement, particularly in the big tech industry. I think it's not fair to read that as saying, therefore, that's the only concern. The report talks a lot, also talks, in fact, more about the importance of ramping up enforcement in challenging exclusionary practices. Right? What the report consciously doesn't do is, but I think by agreement here, what this was not about, we're telling the world what the policy results should be. But right, so like that's open to debate. But what we really, I think, have to offer is, how do you change enforcement so that it accomplishes more than it does? And in particular, the report is very strong in being clear that things like compulsory licensing, breaking up companies, equitable remedies, that there should be no presumption against using them. The government shouldn't be shy to use them. They should adopt the remedies they need to fix competition and that maximize deterrence. So, I think the point is, what you want is people who are going to attack problems and deliver the answer and solve the problem.
Thank you.
Can I sort of follow up a little bit? Yeah, I was wondering what the authors thought about, there's discussion of potential rulemaking at the FTC, and whether the authors thought that might be an avenue to get at some of the concerns that are being raised about big tech companies around non-discrimination or interoperability. Is that a potential vehicle if Congress doesn't act for the agency, or rather one of the agencies, to make progress.
Nancy, John, you want to take that on?
All right. Well, so the short answer is yes. I mean, and I think Michael has Michael and Fiona wrote something about interoperability remedies with ideas about what the FTC could do in their rulemaking. I don't recall whether the report cites it or not, but it might have. But the general view, I think, of our group is, is that of course exclusionary conduct and is something important to address and of course all the tools that the agency has should be used, and that includes rulemaking.
Yep, and I think the report does get into that, does talk about the benefits of prospective rules that channel competitive instincts in markets that are performing imperfectly, or there are externalities that can be addressed through a more prospective channeling competition. Let me go on to the next question if I can. Christopher Marchese asks, setting aside the common sense reforms like better funding, do you think the consumer welfare standard should remain antitrust guiding principle? And if you change it, what other interests would you have antitrust protect? And how would you handle practices that affect those interests differently?
So I'm happy to kick off the answer to that discussion. I'm not sure what others want to weigh in on. The consumer welfare standard is just a shorthand. It's a shorthand for how we interpret protecting competition in a market. And I think there have at times, especially in the recent debate, been some who would cabin it in much more than the courts have cabined it in, than the enforcement agencies have cabined it in. It is not a price standard. It is not does the final consumer pay more for a product standard. It is quite flexible. And Scott Hemphill and I have a law review paper that argues that it is equally effective in reaching upstream harm as it is in reaching downstream harm. So I think it's a red herring to think that we need to move away from the consumer welfare standard as it's understood as a kind of shorthand for competition. And I don't think I would certainly not advocate that. I think that we can accomplish what we need to accomplish in protecting a competitive economy without moving away from that. But I'll let others who may agree or disagree with that weigh in.
John.
May I add one thing, which is that I think the report emphasizes that there are lots of beneficial byproducts from competition enforcement that's focused on competition. And some of those beneficial byproducts include reducing inequality, the way Dan and I have argued about a minute ago, and but also a broader range of social and political concerns are addressed just by virtue of having a more competitive economy. That was always in the 1950s and 60s. That was the way Bob Petoskey, for example, wrote about the political content of antitrust, that there was a great benefit of having greater antitrust enforcement for protecting democracy and protecting the opportunity of small business to compete. And that was a additional justification for strong antitrust enforcement, as opposed to something that would get considered in specific case evaluations and litigation.
Thanks.
So if I could just add, so I think that part of the discourse has sort of missed the boat insofar as there's a conflation of the consumer welfare standard with antitrust as it's been practiced in the last 30 or 40 years, right? So as I totally agree with Nancy, the consumer welfare standard is a broad standard. It does exclude some things, but it's a very broad standard focused on protecting efficiency and competition. But think about innovation, for example. So as Nancy says, lots of people say, well, consumer welfare is focused on, it's static efficiency, price effects, deadweight losses, and innovation's the big story. Well, read the horizontal merger guidelines, right, which says very clearly, we use the word price as a shorthand for all aspects of consumer welfare, including innovation, including variety, including consumer choice, right? The problem is, though, that innovation has been really hard to prove effects on, right? Or at least the courts have not been very sympathetic to claims that anti-competitive conduct or mergers might harm innovation. Right? That's not a problem of the consumer welfare standard as such. That's a question about philosophy, burdens of proof, understanding about innovation and what things are good or bad for innovation, right? Which is a very contested area. So I would say, if your concern is that antitrust law has been insufficiently focused on innovation, and recognizing that innovation is a hard thing to prove, we need to change burdens of proof or presumptions around that. That's fine, but that can all be accomplished within the rubric of the consumer welfare standard. If you read the merger guidelines, that would be squarely within the consumer welfare standard.
Thanks, Dan. To me, I think that's a very fair point, although a challenge is, I think the consumer welfare standard has become a little bit of a Rorschach inkblot, where some people see it as applying very narrowly, not in the fashion you talk about or the fashion horizontal merger guidelines talk about, but really demonstrable, provable, close to beyond a reasonable doubt price effects before conduct or M&A is actionable. And that's, it may well be, it's become a term that has too many different meanings to be applied in a sensible fashion. Doug Melamed always talks about, telling the story of harm to competition and to consumers, and let's get rid of the consumer welfare label because it doesn't really sufficiently articulate what we mean, or it means too many things to do to too many different people. Let me go on to another question. We got time for a couple more, I hope. Mary Cooper asked a question that is fair game given the authors of this report. She says, can you speak to the effect of the revolving door, especially at the leadership level? Do you believe that lawyers and economists who recently represented or consulted for corporate clients should not serve in leadership positions in the Biden administration? I'll start. The fact is, the report does talk about that a bit. And the thought, I think, that went into that part of the report was, on the one hand, the talent you need, the experience you need to be able to figure out how to set an agenda and then implement an agenda, particularly an enforcement-minded agenda. Some of that talent resides in the private sector, and it should not be disqualifying that you've had private sector experience. At the same time, there is a worry that people coming in for a short stay, 14, 18, 24 months, gives rise to the concern that these folks are in for a resume enhancing experience without a really long-term commitment to effective competition enforcement at either or both agencies. The report says, that ought to be factored into the Biden personnel decisions, and that we really ought to ask for, or the administration ought to ask for, a commitment of a minimum of 3 years, enough for people to come in and bond with the career staff to develop and implement an agenda and avoid that appearance that they may be doing this for a long-term gain that is not associated with commitment to assertive antitrust enforcement. Anybody else want to add on that? Or have I preempted the field?
So I was going to just jump in. I mean, I think the revolving door issue is really important, and one does need to recognize. Look, people are affected by where they work and what they see, and I understand why some people want really hard and fast rules. You know, the report didn't take that approach. And in part, I think that reflects that what Bill was talking about, that you need a battery of skills to be effective. And you know, when you think about it, I mean, for example, Thurman Arnold, the most well-known aggressive antitrust enforcer, before he got to the antitrust agency, he wrote the book called The Folklore of Capitalism that pretty much said antitrust enforcement was useless and meaningless, right? So it's not always the case that the people that you can just get rid of a category of folks. You know, I'd also point out folks like Gary Gensler and Tom Wheeler, two of the most aggressive enforcers in the regulatory sphere in my lifetime, both of whom, if you just looked at the resume, they never would have had the job. Conversely, I think you can look, you know, it's not hard to look at people who sort of had the pristine, who would pass a pristine litmus test, but who didn't have the skills to be effective, right? So that's what I think the report tried to do is say, we understand there's an issue, but like the key here is getting people who are going to be successful in effecting an agenda. That means the Biden administration, I would say this, I mean, I think this is really critical. People who really understand what the problem is, who understand there's been a failure, and who are going to attack that and have the ability to implement. And like, I'll take that person, I don't care where they came from, over somebody else who maybe whose resume is more pristine, but is going to end up being less successful. And you know, I get it. Like that, I understand that there are other folks have a different view, and that's reasonable. You know, and we can debate about that. But that's kind of where I see where we were and why the report came out where it did.
Great. Anybody else want to add to that? All right. I think we're right at the end of our time, and let me make a couple of points. First, thanks to everyone, and particularly Dan and Mark for coming in and helping offer some perspective on our report. As I understand it, and Michael, you can correct me if I'm wrong, we're going to pause for 5 minutes, and then we'll come back on, and Michael will introduce the next panel. Do I have that right?
Yes, you have that right.
All right, so right at 2:45, right on time, we're going to take a 5-minute break, and we'll see you all shortly. Thank you.
Great, we're back and ready to start with our second panel. I'm going to just quickly recognize our moderator, Carl Shapiro, Professor Emeritus at the Berkeley School of Business, served twice in the Justice Department, also been very critically involved in antitrust enforcement for years. And I'm going to let him introduce the rest of the panel. And Carl, you don't need to reintroduce me.
Okay, thanks, Michael. Hello, everybody. Thank you for sticking around for our second panel. So the members of the panel, we have Fiona Scott Morton, professor at Yale School of Management, Tim Wu, professor at Columbia Law School, who are with me, authors of the report, along with Michael Kades, and our two commentators who are Ganesh Sitaraman, professor at Vanderbilt Law School, and Josh Chasovin, who's a partner at Wilson Sonsini. So this panel picks up on the fact that this report is rather ambitious, maybe even unusual for an antitrust transition report, in that while it is certainly directed at the FTC and DOJ, it's looking more broadly. We're looking to Congress to do things. We're looking to the White House to do things. So this reflects the fact that antitrust is in the news and is getting a lot more attention more broadly in recent years. And Heather's introduction, the wonderful remarks this morning, I think reflect that as well. That labor economists are interested in this because it's affecting jobs, not just it's not just industrial organization economists. The whole issue of inequality, the declining share of labor, those are on the table. And I think it's a real credit to Heather and the Center for Equitable Growth that they've hired Michael and picked up this issue of corporate concentration as an issue of equitable growth and opportunity for all. So we're gonna explore these broader issues in the that are in the transition report. Let me start with the need for legislation. So we do call for Congress. The transition report emphasizes the need for Congress to update the antitrust laws. And there's this real tension between wanting the agencies to do more, we've heard about, but also the feeling like, how much can they really do without more legislation? And Congress has stepped in the past to correct or expand the antitrust laws. The Sherman Act started it, but Congress stepped in after antitrust was a big issue in the 1912 election to pass the FTC Act in 1914 and the Clayton Act as well. And there are subsequent moves by Congress, but we haven't seen anything for quite a while. So the first question for the panel, and Tim, I'd like you to start here, is why do we need legislation now? What would be wrong with just pursuing enforcement and letting the common law develop through the courts? Tim.
Thanks. It's great to be here, and hi to everybody. So I hope my microphone is working well. I think we're overdue. I think we've been on a run for the last, let's say, 40 years, a kind of experiment with the courts. But I think the results are in. The courts have wandered far too far away from the congressional intent in the passage of the antitrust laws. They have meandered into almost eliminating some of the important, close to eliminating some of the things that are mentioned in the Clayton Act, like predatory pricing, tying, maybe not as bad, tying, and other areas, creating new barriers to entry for plaintiffs, strange formulations like the American Express opinion. And it's not just the Supreme Court, or also creating sort of new burdens to avoid regulation, like in Trinco, Credit Suisse. So there's a whole huge buildup of backlog. Actually, it's kind of like the buildup almost of in California of all this dead wood that hasn't been burnt or something like that. It's just overdue. And people are getting mad. There's going to be an explosion. And as you said in your introduction, the courts are delegated the authority to interpret the antitrust laws. That doesn't mean Congress can't step in and tell them when they've gone too bad. And I just want to say it's not just the Supreme Court. The district courts have gone in some wild directions lately. Failing to recognize even straightforward theories of harm. The Ninth Circuit and Qualcomm, a recent example. Somehow, even if I'm not a huge advocate of consumer welfare, but I do think harm to consumers should count for something. I was surprised by the Qualcomm's. I don't even know what that is. It's a nobody welfare standard. So, the courts have, it's a little funny to be complaining about an activist judiciary, but I think it is what we face in the antitrust area. And it's time for Congress, to reassert its authority in this area.
Fiona?
That's,
Yes, sorry. My chat box was covering my microphone. I agree 100% with what Tim has said. I would second what the earlier panel discussed, which is that we have now an accumulation of evidence that there's a competition problem in the United States, that antitrust enforcement has contributed to this competition problem, that on average, we care about having competitive markets because they both increase efficiency and they also help with inequality and with entry and entrepreneurship and small business. And so what we need to do is get back to that understanding of the value of antitrust. And I think there's really a bipartisan appreciation of that now, that we have strayed too far. So that's a good place to be. And I think the economics justifies it for sure.
So let me now turn it to our commentators, and Ganesh, Josh, we're going to do this a little differently than the first panel, which is rather than have you make an overall comment about the report, let's do it in chunks as we talk about specific topics. So here we are, this report calling for legislation. That's a pretty heavy lift. We've heard briefly now why we think that's needed. What's your reaction to that, Ganesh?
Well, thanks so much, Carl. And just to start off, let me just say thanks to everyone at Washington Center for Equitable Growth for putting this event on, including Heather and all the staff, and also to all of you for writing this paper. It was terrific to see this work come out now at a moment when there's lots of thinking going on, and I very much appreciated both how strongly everyone in all of the authors acknowledge the problem here and want to move forward, go beyond the kind of business as usual that we've seen. I agree with the report that we should be thinking about legislation and that Congress should be acting. And I think that's an important place forward. But what I would add is that if we really want to think broadly about competition as a value, we should think about legislation not just in the narrow areas of the antitrust laws or agencies, but much more broadly. Throughout our history, we've seen that Congress has passed sector-specific legislation. One example is the Packards and Stockyards Act in the agricultural sector, effectively a competition law, though it is not the FTC or the DOJ, and so often is not thought of in the same way. But we should be thinking about legislative reforms potentially in multiple sectoral domains if we want to infuse our economy with a greater spirit of competition. A second legislative point in the same vein is just thinking about how competition can actually show up in any sort of policymaking process. My favorite example here, just in the way that people used to think about competition and antitrust and anti-monopoly values in Congress, is the Panama Canal Act. 110 years old now or so, has a provision in it that says that you can't bring a ship through the Panama Canal if the company that owns the ship is in violation of the Sherman Act. Extraordinary provision that someone thought to put in an anti-monopoly rule into the Panama Canal Act, not obviously about antitrust or monopoly or anything like this on its face. So I think there's a place where Congress can actually take a much broader role in thinking, how do we build a competitive society? How do we really use the laws on whatever the policy issue is? Because ultimately, the economy is constructed in part by the legal and policy choices, and Congress, their decisions shape how the economy operates. And so I agree with the report that we should do legislation, but would actually push Congress to maybe be a little bit more broad in how they think of doing antitrust and competition lawmaking.
And Josh, you've got a lot of experience both in agencies and on private practice dealing with antitrust. What do you think of legislative change? Is it exciting? Is it scary? Both?
All of the above. So first of all, thanks very much for inviting me to speak. And I'll say at the outset, I represent a number of clients with some issues and some interests in these topics. These are my views, not those. And I'll also say at the outset that I really sort of approach this as a practitioner, sort of someone who has been on the line in both places. My bottom line is I do not think the legislation will be helpful. I think that antitrust enforcement is exceptionally important and very aggressive and very successful antitrust enforcement is exceptionally enforcement. It preserves a competitive economy. It eliminates the need for a lot of laws that will be worse. And I'd like to see the government win more cases rather than fewer if they're correctly brought. But for the following reasons, I think it's sort of off. First of all, the big motivation, and I'll be brief because I know we're going to cover a bunch of topics. The big motivation for a lot of the push for the legislation is the courts are making doctrinal mistakes, that they're just not seeing it correctly. I don't really see it that way. I view winning cases and losing cases much more of a tradecraft business and less of an ideological doctrinal business. And I'll give a few examples in a minute. And also, I also think that, the laws that people are kicking around, they actually may make it harder to win for the government to win cases, not the other way around. It's harder to write than you think. And when you push on one lever, you're pulling on another. And I'll give an example of that. So just to take a couple of examples of how I see it as tradecraft as much as doctrine. So the Amex case, I think Tim mentioned it. Everyone's upset about the Amex case and all spun up about that one. And I understand that, and the losses sting. And we've all won cases and lost cases, and they're not fun to lose. So one view of Amex is, well, people made a doctrinal mistake, or the court made a doctrinal mistake. The other view of it is, look, this was an exceptionally hard case to win. The record was very exposed on appeal, and if the government did it again, they might win. So to be specific, what was challenging to me from Amex as a practitioner is the shares were low. Amex was in the 20s. Never a helpful fact as a plaintiff. Two, the consumers, the users of the actual product at issue thought it was fantastic and loved it. So you didn't have them to help you out. And three, I encourage people to read the records as well as the decisions. If you look at the record and what the merchants testified to, none of them testified they were going to pass on the higher cost to consumers. So you didn't have this nice story about, well, harm to consumers was coming, less well-off people were paying for others' frequent flyer miles. If you run it again, that way, you might win. Conversely, Microsoft. So Microsoft is identified in the report as an example of doctrinal fidelity, that the court got it right, that the decision was a big success. And I think the court did get it right, and the decision was a big success. But I would also add some other variables into why the government won. A big reason the government won was not so much ideological or doctrinal purity, but the lead trial lawyer for the government walked the Microsoft witnesses down the lane and closed off the doors. And at the end of those crosses, the presiding judge didn't believe a word that Microsoft's witnesses were telling him. And when that happens, no school, be it Chicago, Harvard, or anything else, will save you. So it's not that ideology doesn't matter and doctrine doesn't matter, but I think when you look at these cases, you have to realize that a lot of them are the first sort of step up to the plate. And that if you do as Michael and Marcus Meyer did and others did, and take another crack at it, I think the results will change. So that's a bit longer than I wanted to go. I'll talk to some of the issues in the legislation as we go forward.
Well, brushing aside your concerns, we're now going to proceed to dig a little more into what legislative reform might look like. The majority report from the House of Representatives from the Antitrust Subcommittee on Competition and Digital Markets calls for significant legislative reforms to the antitrust laws. And the report, by the third way report by Representative Ken Buck for the minority there, although more modest in scope, also expresses support for legislation that would create new presumptions of illegality for certain types of mergers, and would, quote, remind, quote, the agencies and the courts of their original congressional intent behind the antitrust laws. So there seems to be significant support. Let's first talk about mergers for new presumptions of illegality. And my view as somebody who's been involved in a lot of these mergers is that for the government in recent years, for sure, is that the hurdles are really excessive for the government to win. And even when the structural presumption is established, following Philadelphia National Bank, it's not necessarily respected by the trial court. So what sort of legislative changes could actually be made here that would correct for some of these problems? And where's the report suggesting we go in that direction? In this case, I'll have Fiona and then Tim and then the commentators.
Okay, great. Thanks. I just want to react quickly to Josh's remarks. I'm thrilled to hear that we can get out of this hole by hiring just better lawyers at DOJ. I'm sure Josh can handle it.
That's actually not what I meant. That's not what I said.
Anyway, in terms of changing the law, I think we definitely need to do some work on nascent and potential competitors. I think it's widely recognized that that is an omission in the way that we set things up now. And when we look at some of the more well-known examples of mistakes that or places the agencies have been unable to successfully enforce, it's been competitors that were nascent or potential. And Tim has written about that. I think the horizontal merger guidelines presumptions perhaps need to be codified into the law so that judges don't have a choice about that. And as you mentioned, the merging parties may need to bear some of the burdens, since they have both the incentive and the information, of explaining why their merger is good. So if certain conditions were met where we have good understanding that that merger is going to tend to be bad, harmful on net, that we would place the burdens onto the merging parties. I think those are really the biggest ones in the merger area. So I'll stop there and hand it over to Tim.
Let me push a little bit, Fiona. So one could codify and reiterate the structural presumption in some fashion, but it is Supreme Court precedent. Would that do it, or do you want to create other presumptions as well?
I think we probably do need to, to create other presumptions so that we can lower the resource cost to the government of enforcing against sort of obviously harmful mergers, where we know from past experience that markets are concentrated, shares are high, we have strong evidence of head-to-head competition, and proving that water is wet, as Michael Kades likes to say, is really not a good use of anybody's time. We want to deter those mergers. So setting up the law to do that is going to be very important in a setting. If you want to achieve good deterrence so that the government's spending its money doing important cutting edge things that are difficult and not proving water is wet every week.
Tim?
Yeah, so I'm glad we're talking about merger reform up front, because if you want to talk about one area that is the most drastically in need of reform, it is mergers. And, if Congress did one thing, we all know it's better to say Congress do 40 things, but, Congress doesn't do everything. We want to do one thing, it would be reforming mergers. It is a crisis, and a lot of the market power problems we're talking about in this report are, when you point the finger, merger review, and not only that, the government has had a tough time, even when it has really strong cases, stopping them. 4-3 merger, Sprint T-Mobile. Even 10 years ago, people would think, well, 4-3 merger, they're going to let that go through. Went through despite with some cockamamie 5G arguments, which I won't repeat because they're not worth it. Anyway, let's not get into individual cases. But the Justice Department's failure to get involved in a tragic and difficult to understand move. But no, the merger is in a crisis, and I think merger review is in a crisis. Fiona has listed some of the big ones. If your merger is so great, prove it. And actually, frankly, some of the investors might appreciate this too. If you hang out, I spend time at Columbia Business School, where half the time is spent in our class trying to figure out what is this merger about, other than enriching people who happen to have options that are about to, that haven't had an actuation moment or fees and so forth. There's a lot of bad mergers, even from a private perspective. So if this merger is so great, and given the public costs of mergers and the private benefits of mergers, I think putting the burden of proof, especially for the big mergers, to prove their benefits important. And the other huge blind spot is this problem of nascent competition. We've had a pattern in tech industry, and as Fiona said, something I've been writing about with Scott Hemphill. We had between Microsoft, Amazon, Google, and Facebook, they finished more than 600 mergers without a single challenge, with one partial condition over a period of 10 years or something. And people say, well, what happened to the tech industry? It used to be so competitive. There used to be all these new startups coming, and we've just had an oligopolization of that industry, mainly through the device of buying small companies, consolidating talent. Some of the stuff doesn't even register on any kind of price index that you could possibly measure. So nascent competition, a big problem. The last thing I'd say is I think this is a broader conversation about price metrics. I think there's too much of a focus on this, on just needing to prove a price effect in every single challenge to a merger. Now, the Consumer Welfare Standard doesn't say you have to do that, either does the Clayton Act, but many courts seem to want you to do that. And I think, in something like a nascent competition case, it's not going to happen. There's also other markets, markets for attention, markets for data that people might be buying and trying to gain power in. Very hard to get through this sort of price-centric focus. So I'm concerned with price fixation on top of the other two concerns.
And I would just say, in response to people who would say, well, the government wins a bunch of merger cases, they lose some, what's the problem? Is it's too hard for the government to win. The hurdles are too high. The structural presumption is not respected enough. It takes more resources to do that. And the boundary on which the battle is being waged is too lenient. So just looking at the win and loss rate is not really that instructive. You really need to look at the evidence. And again, going back to Heather's remarks this morning or earlier, we're really talking about responding to accumulating evidence, and the whole report is doing that. We're acknowledging the empirical evidence, and that applies on the merger side too. So with that,
can I come back in on that? Can I come back in? It is a mistake. I strongly agree. It's a mistake to say, well, look, they won these ones and they lost these cases, because those are the cases that the government brought. How many situations, let's say Facebook buying Instagram, WhatsApp, even though they have an email saying from Mark Zuckerberg, well, we've got a problem. They're a dangerous nascent competitor. We need to neutralize them. They didn't bring the case. Now, why doesn't the FTC bring the case? Because they're concerned they're going to lose. So there's, for every one case the government brings, there's several more that they think are worthy. They don't bring because they don't think they can win. And so, it's really, looking at litigated cases is terrible the way to look at how the merger review is looking.
And one of the things I'd emphasize, I think I can say also on behalf of all the authors of the report, is we really talk about deterrence. And so you need to have a set of rules that are clear and strong to deter, whether it's mergers or something else. And that's been a failing. Now with that, Josh, since you're the designated contrarian, probably defended a bunch of mergers over the recent years, what's your reaction?
So it's a couple of things. First, to Fiona's point about the skill level, that's not the way I think about it, as you need better lawyers or better economists. The lawyers who trained me at the Antitrust Division are fantastic. Michael and Marcus and Brad Albert, they were fantastic lawyers when they lost sharing, and they were fantastic lawyers when they won a bunch of cases. It's just the reality of this business is you can't assume you're going to win a new case the first time out. And yes, I understand the disappointment if you don't, but I really believe it's in a practice and experience sport. And what the record has shown.
No, Josh, that doesn't make sense. Either you have to say that we need better, if we want to move the ball away from where it is now, then either we need different policy, different rules of the game, or we need better players. It sounds to me like you're just saying keep going where we are. And I think that's not acceptable.
Okay, well, let me just finish. I think that if the government identifies a problem, as the commission has done multiple times, and puts its mind to it, which I have no doubt they will, they're going to win. And they're going to win far more often than they lose. And I think that's what the people on the line who do the cases and put them together believe. That, I worked there forever for lots of different people, and they never really talked about doctrine or challenges of the bar being too high. Rather, what they do is they go out and talk to everybody, literally or figuratively, who sells the product out of the back of a truck and figures out how to do it, and that will win. To take a really specific point, you and Carl are the best in the world at what you do, and you showed it in T-Mobile Sprint. You were fantastic. Sometimes things just go a different way. Maybe the judge made a mistake, maybe he didn't. But I don't think in that case, it's because he got the doctrine wrong or he misunderstood the purpose of the antitrust laws. He just saw the facts as they were presented to him and thought there wasn't going to be a problem because, notwithstanding Tim's point, output was, capacity was going to go up 600%. And that's the way it goes. The alternative is, to really get to the legislation, unless you, to put a finer point on it, unless you tell the court sort of in a prescriptive way what the result is going to be, then I think you're always going to have battles of the facts, and the government's going to win a bunch of cases, and I think they'll win most of them, but they will lose a few. And we can talk to the specifics in a minute, but I think some of these merger proposals are actually going to make it harder for the government to win.
Ganesh, want to comment on the legislative move here on mergers? Anything on this?
So, go ahead.
Let me say one brief thing about mergers, but then I think Tim wanted to jump in as well and the conversation with Josh, I think. I agree on the merger question, and in a way it gets to Josh's point, which is if you're fighting over facts and you're going to win some, lose some, the standard policy response to this that all of us learn in law school and that we all teach is you can have rules and standards, and there's problems with standards, there's problems with rules, but you can actually set rules or standards at different places. And so shifting presumptions will mean that some set of cases are going to go in a different direction because you've decided to shift the presumption at a legislative level. So I think there's a case to be made for that if you think that overall, we're not seeing enough enforcement and not enough successful enforcement. Maybe that's for the reason that Tim suggested, which is that there's a chilling effect because you think you're going to lose cases, so you're not bringing them, or because even on the cases that you do bring, you're not winning at the rate that the government should be. The other thing I just wanted to point out here, just as an additional comment, as we're talking about merger rules and deterrence, which you mentioned, Carl, is how we think about remedies in this area. And I suspect we'll talk a little bit about that later. But I particularly wanted to raise it just because, you know, one of the things I think is striking is that there's at least some research, and I'm thinking of John Quokka here, that conduct and conditional remedies in the merger context are just not effective. They're not doing what they're supposed to be doing, even on the own terms of price. So you don't have to get into neo-Brandeisian theories of democracy or competition or something else, but on prices themselves, those remedies are ineffective at accomplishing the goals. So I do think that if we're thinking about merger reform, we have to be also thinking about remedies and remedies reform in this sector as well.
Carl, let me give you an example of how I think it's challenging. So one of the proposals out there is to create re-emphasis on the structural presumption that to, you know, underline Philadelphia National Bank and go, we really mean it, and set the thresholds and go with it, and that's it. And I understand that and makes sense. I think one of the consequences of that, okay, is that the more you do that, the more you put pressure on how you litigate the product market, and that the problems the government has had in proving unilateral, you know, wins in unilateral effects cases involving differentiated product markets will go up. So if you go look, you know, the presumption is it. Then, you know, judges will look at the facts. They'll just back up the competitive effects analysis into the market definition scenario, and you'll do the trial there. And, you know, the more you do that, it'll get harder to win cases where the product market's kind of a mess. It's blurry, as you've taught me. It's not really a relevant concept anyway. It's all just a differentiated thing. And the problem is, well, it's the merger of next close substitutes, and that's what you should focus on. But if you elevated the presumption above all, it will make it harder to win those cases.
Well, it might be that you'd also need to clarify market definition along the ways that the 2010 guidelines do, which indicate you can have rather narrow markets under the hypothetical monopolist test. So maybe you need to do that too in order to prevent this type of weaseling around it. Tim, you wanted to get in?
Yeah, I'm sort of shocked by Josh's comments. They approach the level of legal nihilism that I hadn't fully expected, which is to say, you know, the idea you can't, we're not talking about like, you know, litigation strategy. You're talking about Congress changing the law, and you're saying Congress cannot change the law possibly to ban certain mergers. For example, to ban 4-to-3 mergers because somehow it'll always come out. I mean, I guess it reflects the confidence, you know, of the defense bar that it can always spend enough money to try and get a judge to do what it wants or something like that. But it is a form of legal nihilism. I mean, to say, for example, you can't set up, you know, go back to older systems and say 4-to-3s are presumptively illegal and we don't care about, you know, countervailing efficiency. State Congress can't do that. Suggests that, like, are you saying Congress, you know, we don't have, the people cannot pass laws that will change the course of merger review? That can't be right.
No, that's not what I'm saying.
I mean, that can't be right. I mean, there's got to, Congress has the, we're not talking about litigation strategy, talking about Congress. Anyway, we can move on, but I just think it reflects a kind of profoundly anti-democratic idea here that people have no real, you know, power over changing antitrust law because, you know, we'll find some kind of way out of it with a product market argument or something like that. You know, I think we've actually seen here the core of the problem is there are some people who do not believe, who believe there's some sort of sovereignty outside of Congress's sovereignty and I'm Josh, I don't want to, you know, associate you too strongly with this, but this idea that there's no way Congress can improve the situation is crazy.
What about a version of this, Tim, that says it's hard to do this for Congress if you have a hostile judiciary?
It is hard to do things, but you know, Congress probably didn't like the antitrust law at all, and even a strong judiciary. This goes back to Ganesh's point about rules and standards.
Yeah,
Josh, your name was mentioned, so you have 15 seconds.
I'm sorry?
Your name was mentioned, so you have 15 seconds.
No, I think Congress can regulate away certain mergers. Just if you do that, you don't need a judge or a trial.
I mean, that might be an advantage. That's, I think, the point that Tim's
right. And in that case, you know, what the inquiry should be is, well, let's look at the costs and benefits of doing that. My point is that if you're maintaining a judicial framework, which I think is the right thing to do, I think judges, regardless of who appoint them or what they do, think about this in a factual way. And if you close off one avenue of looking at the facts, they'll look at another. and there's nothing wrong with that. Ultimately, what this boils down to is when the government persuades the court that bad things will happen on price or output, they're going to win. If they don't, it's harder. And then you figure out a better way to do it and win the case. That's it.
Okay, well, I think part of the issue is how persuasive does it have to be, and when do you establish a presumption, how strong it is. So the report, our report we issued today is definitely pointing in the direction of stronger presumptions and that are harder to rebut, and that really getting the courts to respect them more. And that's a very familiar notion to the law, he says, as an economist. Let's move on away from Congress to well, not away from Congress, from the substantive reforms to the procedural reforms. We have a specialist on this panel, Michael Case, who's going to speak to this. So I get to make him laugh. That's good. Happy birthday. So the transition report calls for a series of procedural reforms to make the antitrust laws more effective. I'm just going to list a number of those, and then Michael, I'd like you to talk about, why we think these are called for and will make a difference. First, to affirm the right of the two federal antitrust enforcement agencies to obtain equitable monetary remedies, to update merger filing procedures and adjust filing fees under the Hart-Scott-Rodino Act, and to streamline small deal review through a quick file system, to modernize the Federal Trade Commission's jurisdiction and process, and to provide the Antitrust Division at DOJ with authority to study industries similar to what the FTC already has under Section 6B. So Michael, why don't you address some of these, and then I know Fiona wants to weigh in as well.
Great, thank you. So, right, I think this part of the report was looking at, so you can have the big, as you guys were having the sort of the big debate about the substance of the law. And then there's like lots of good ideas out there. And we try to sort of come up with a meaningful list of things that we thought shouldn't be controversial, but would be of measurable significance to improving enforcement. And so start with equitable monetary relief. And for those of you who are not, like antitrust lawyer geeks, that just means that when the government goes in and proves something's anti-competitive, they can seek to deprive the defendant of the money they earned by violating the law, or the money needed to restore and give it back to the victims. And this is a authority, right, that the FTC has used for 40 years, and unbroken judicial agreement that they had this authority. And then recently, the Seventh Circuit sort of said, we don't really like the way old judges did statutory interpretation. So, that whole stare decisis thing, we're not going to be bound by it because we wouldn't have done it the same way in the first place. Showing that I didn't really understand stare decisis when I went to law school, because that seemed the exact opposite of it. So that's in front of the Supreme Court. If that goes away, the burden on what you're doing is telling companies that the most the FTC can do, or the most DOJ can do to you, for the types of harms that are causing consumer harm, monetary harm, what they can do is they can make you stop. So particularly in fields like pharmaceuticals or anywhere else where the incentives are massive, where denying generic entry for a year is worth hundreds of billions of dollars. If you take that away from the government, you are going to get more of those cases, and the FTC will have to prosecute those cases. And that's going to mean there are a whole bunch of other cases that they won't process. So like, I would go further. I would actually give the agencies finding authority. But again, this part of the section was, okay, what should be reasonable that anyone who believes in antitrust enforcement should agree to? So there's that. The second thing is, when we look at the FTC and DOJ budgets, that most of their work is generated by Hart-Scott-Rodino filings. Okay, most of that work is done on very large deals, $50 billion or more, or that's the biggest chunk. But the fees that are supposed to just pay for all that, those have not been adjusted since 2000, in 2 decades. Now, on the other hand, for the companies, we adjust the thresholds every year. So the idea is, one way to deal with to take the budget off of sort of politics is to say, give the agencies a source of directed funding related to the amount of work they have to do, and make it reflect the real costs of money, not what things cost in 2000. Which again, I think would put the agency in a much better position, both agencies on a much more secure budget funding. I think that's a good time. Why don't I turn it over to Fiona, and so we'll get change in voice, change a little for the audience, and we can come back.
Sure. One of the ideas in the report is to try to do something about mergers that have a very important geographic component, such as a dialysis clinic or a physician practice group, where you can have small markets that are nonetheless very important markets because people can't drive very far for dialysis treatment. So these are, you're not going to be able to seek a substitute that's hundreds of miles away. And so you get mergers in these situations that are mergers to monopoly, and yet the dollar amounts are low. So we need a way to catch these, because in rural markets, particularly in more sparsely populated markets, you have many instances of concentration that are not stopped because nobody's notified about them. There's no Hart-Scott-Rodino filing required. The states aren't set up to handle these. And so the idea we thought is, look, let's make a quick file system that goes down really low in terms of the number of dollars that's required to trigger it, but that really only is of interest to agencies in, like, the agencies would pick up the filings only in the industries where we are concerned about this kind of problem. So physician practices, dialysis clinics, funeral homes, stuff where there's a strong local component. And that if you could look at those, you could very easily assess if the two dialysis clinics in a town are merging to monopoly, then you got a problem. And that's actually not a hard case to prosecute, but you have to know about it in order to do anything.
Okay, Michael, back to you then on just very briefly, if you would, if you want
Sure.
to, on some of the other procedural reforms.
Yeah. One of the other procedural reforms, and this is in the weeds, but when the FTC does administrative litigation, which part of that's the purpose of the FTC, thinking that sometimes having an expert agency think about the law and economics has some advantages over a district judge who's a generalist. The problem is that if they issue that decision, and where you'd really like to use that authority is where you think the doctrine's sort of off kilter, right? So maybe you think predatory pricing does not reflect where the economics is, or refusals to deal doesn't reflect where the economics is. And so the FTC does a case. The problem is the defendants in almost all cases can appeal anywhere they want. So they're always going to go to the case where the circuit said, oh, we already decided that, you're wrong, FTC. So that's not the way it works in most other agencies. So here, it's just a simple fix to say, you don't get to forum shop your appeal. You have to go to the home circuit of either the FTC, DC, or your own home circuit. And then the last one I'll talk about is giving DOJ the authority to do policy studies. This is just like, look, the FTC can do it. It's very valuable. We should give the DOJ the exact same tool precisely so that it'll help them in their enforcement mission.
Okay, moving along very quickly, Josh, what do you think about these HSR reforms? Can your multi-billion-dollar clients afford a little higher filing fee?
Yeah, I mean, so generally, I'm in favor of streamlining and making the process more efficient, more comprehensive. I think that the agencies will benefit from more dollar allocations. I think that will facilitate pro-competitive enforcement, which will eliminate the need for regulations, which will be worse. So I'm all good with that. I think it's probably better to increase the funding through a general expenditure than upping the filing fee, given the way the sort of pull and refile process works and is a bit opaque these days. But yeah, more cash is good. I think Fiona's right with catching deals that are reducing competition. You should do it and figure out a way to do it. On the equitable relief, I think that's fine as long as you have some guidelines as to how to do it. It can't be, well, look, we don't like you, so it's going to be 10x, and we do like you, so it's X. So you got to come up with some framework for doing that in a way that's consistent and transparent. And on studies for DOJ, I think that's fine.
Let's move on to another proposal in the report the use of FTC rulemaking in the competition area. The transition report calls on Congress to confirm the FTC's authority to engage in competition rulemaking, but we also, I think, believe the FTC has that authority and should use it even if Congress doesn't act. This is not a particularly familiar area for antitrust practitioners because the FTC has, as I understand it, only used its authority once in the 100+ years that the FTC's been around. And it wasn't particularly impressive or wide-ranging. It involved this price discrimination, the sale of men's and boys' pants, which, while very important to me, is not economy shaking, I don't think. So I guess there's, so one question is, do we need Congress to do this? But whether or not they do that, is this what can really be done in this area with rulemaking to complement the litigation approach that antitrust practitioners are really familiar with? Fiona and then Tim.
I think that the rulemaking that I would like to see, I mean, I'm not maybe going to reflect the whole range of opinions in the report. I have a particular niche view on this, I think, which is there's an interesting nexus between consumer protection and competition that we don't often exploit. So when consumers are confused about the product or can't see the features that are important to them because they're not salient or they're obfuscated by the firm, they don't make choices in response to lower prices and higher quality. And when consumers don't respond to lower prices and higher quality, then there's no incentive of the firms to offer them. So I feel like rules that are at the nexus of consumer protection and competition would be particularly valuable for the FTC to go after because they both protect consumers and they make markets work better. And it's really clear, I think, often why they're going to be beneficial to consumers. So I feel like that would be a great place to start, partially because the FTC has both of these functions, and partially because I think the digital economy is filled with examples of this, where consumers are not able to see what's really important in these choices, and as a consequence are not making very good choices, and then that creates competition problems, which then competition enforcers are trying to solve. But of course, if demand were more elastic to begin with, maybe you wouldn't have so many competition problems. So I'll just offer that as one potential direction. So
Tim, let me tee it up a little more for you, which is, it seems like this is an authority that's dormant, unused, particularly given what the authors of the report believe, which is we really do have a competition problem. It's like dust it off and use it. But even Commissioner Chopra, who's pushed in this direction, you know, he indicates you need to like study the industry carefully and maybe have enforcement actions, or, you know, so has some pretty high hurdles before you do rulemaking. How far can we really get here? How do you see this working?
Yeah, I think there's enormous untapped potential in pro-competitive rulemakings, competition catalysts. There's a lot of different phrases for these things, and Commissioner Chopra does need to have some credit here from this group for putting this back into the radar screen after sort of being submerged under the water for no really good reasons. There's been some agencies that have outside the antitrust field that have had a lot of important success. The FCC is a good example of an agency. Not every rule of theirs has been perfect, but they had an enormous success, particularly in the 70s, in opening up the telecom industry, using mostly rulemakings. And I think there's all kinds of potential. And I'll say the FTC, in addition to the men's trouser rule that you were talking about, or whatever it was, they also had enormous success. One I think is a great model with prescription eyeglasses, which was actually a consumer protection rulemaking, but with competitive impacts, a little like Fiona was saying, where traditionally the prescribing doctor would then sell you your glasses without giving you a prescription. We sort of take it for granted you get no, he wouldn't give you a prescription, just okay, here's your exam, and would you like glasses? Okay, those will be $700. Okay, you know, what are you going to do? You don't, without your prescription, you can't actually shop around. So the FTC wrote a rule forcing you to give the doctor to give you a prescription, so you could either shop with the doctor or, as many people do now, either visit another shop or go to Warby Parker or whatever. So, this was an enormous, and we don't even take it for granted that there's competition in the eyeglass space. There's another industry doesn't have this rule, is it's a great study, is hearing aids, where hearing aid prices are still somewhere like $5,000 for components that cost $100. The industry is terribly uncompetitive. And of course, the ear doctor, measures your hearing and then says, okay, that'll be 5,000, whatever it is, 4,000, I'll give you a discount, $3,000. But whatever, the industry is completely locked up. And so there's all kinds of potential, I think, for pro-competitive rulemaking. It's really low-hanging fruit. And, the industry, the FTC hasn't used its power. Now, does this mean, I don't think what this means is that you say, well, we lost that case, let's do a rulemaking instead, sort of kind of thing. I don't think that's the idea. I think, like you said, Carl, I think that the next, in fact, I'll just speak directly to the transition and to the Biden administration incoming, that it should be a priority to reactivate this power and figure out an area, just target the low-hanging fruit and figure out where you can bust open competition that is stagnated for one of various reasons. So I think it's kind of a no-lose proposition. And the weight of authority, there's people who are paid to say the opposite, but the weight of learned authority says you don't need further congressional authorization to go forward. Congress gave this authority in 1914. So that's where we're at.
Ganesh, I see you nodding. What do you make of this initiative we propose in the report?
So I think this is a really important point, and it actually gets at something that is quite profound and surprising when you think about it for a moment, which is that virtually all, maybe all of our economic regulators make rules pursuant to statute, and then courts review those rules using doctrines we're all familiar with, like Chevron. And the area where this does not happen is in the FTC and with antitrust. And it is sort of surprising, it's not every area, but it's sort of surprising that we don't have more rulemaking in this area, when we particularly have an arena in which there's a lot of things that are very technical, that are focused on particular markets, particular kinds of harms. And it's weird that we would think that judges would be well equipped to make those kinds of assessments. And more broadly, it's weird that we would think that judges should be policymakers in deciding which things are considered appropriate or not appropriate to be regulated in the first place. Why, for some reason in this area, we think, just as a normative matter, not as a historical one of which we could tell stories, but why as a normative matter today, we think that judges should be policymakers determining the scope of what is allowed or not allowed in terms of competition. Policy is sort of beside me. We do not do this in other areas. And so I think this is a really important space where you could imagine an FTC making rules as Tim suggested. And I think what it would require, as Commissioner Chopra said, is serious investigation and work like other agencies do. The SEC, all the banking regulators, the EPA, all these agencies don't just make rules willy-nilly. They engage in extraordinarily extensive fact-finding and records. They do a lot of work in the notice and comment process before issuing a rule. I think we can imagine that in this sector too, and it could be helpful. One thing that I would just add to that, because it sort of links back to the prior set of recommendations, and this question of DOJ doing investigations and having more authority there, I think that's important. But one thing I would add for both agencies and for everyone on the call, I'm a law professor. Most of us here are lawyers or economists, I suspect. But not all knowledge is held by lawyers or economists. And it would be, I know it's a shocking thing to say, a statement against interest for my own profession.
Oh,
but
have them removed immediately. Have them removed.
Exactly. But both of these agencies, as we think of what we're doing, should be paying a lot of attention to the diversity of professional backgrounds of the people who are hired to do these investigations. Former investigators, people who are technologists, people who have deep subject expertise, historians, sociologists, any number of accountants can be very helpful and get used. But I think we often don't think about that. So as we're thinking about more resources, I would want to make a pitch also for thinking about the diversity of information and experience that's used in both agencies as they're doing these investigations.
So let me emphasize this. If the agencies are going to do these investigations, as you point out, they're resource intensive. So this links back directly to the need for more resources. Let me just to give an example though to see where this goes. Take data portability, which people are talking about a lot in big tech, like that could help promote competition. You know, let new entrants come in, maybe weaken some of the power of the incumbents. Is that the sort of thing that the FTC, you think you could pass a rule, you know, requiring data portability subject to some privacy protections? I guess Tim or Ganesh, I feel like but maybe Fiona, any of you, is this the sort of thing that they could do, would have the authority to do? Obviously there'd be some resistance perhaps. Tim, I see you.
Yeah, I think Fiona's written on this, but I guess I'll just say yes and yes. I mean, you got to study and make sure that you're doing more good than harm with the rule, and the privacy concerns are not trivial. You know, among all other people, I heard Bill Gates endorse this rule the other day, so it's not like it's at the weird edge of insanity. Just to maybe in DC, you know, DC has a strange attitude towards these things. But yeah, there's a good example. You know, and I guess I reiterate the idea is a loaded low-hanging fruit for things that just aren't done well through litigation. I mean, we're kind of like, look, I like litigation as much as the next guy. It's fun. You know, get to go to court, judges. It's got a lot of entertainment value, but like, it's not actually how most economic regulation happens. And if you don't think we're doing economic regulation here, you better go to a different panel.
Yeah.
Fiona, you want to comment on this too? Because it seems to me like under Trinco, it's very hard to do this under litigation also.
Yeah, and I think a facility like data portability requires coordination across the players, which really is best done by an agency like the FTC or supervised by the FTC. So we're going to make a data standard, and it's hard to argue with the idea that the consumer ought to have access to her own data. I ought to be able to download what I did at my bank last year or what I bought at the supermarket or something like that. And once the consumer has the ability to download her data that she used last year, then she can take it to a competitor and say, here's what I bought last year. Now you can suggest things to me, market to me, you know what kind of person I am, and I'll get a better service. And that seems like a really excellent way to stimulate competition without doing much damage. It's quite a light touch thing. And it feels to me like consumers really, it's hard for me to hear an explanation for why the consumer shouldn't be entitled to have her own data. I mean, it seems very reasonable.
Okay, let me move on to our last main topic before we'll turn to Q&A, which we welcome, which is this proposed White House Office of Competition Policy. So the transition report calls for what we call a whole of government effort to promote competition. This includes regulation and deregulation with an eye to competitive effects. The centerpiece there in terms to make this operational is this proposed office within the National Economic Council in the White House. And we envision it serving several functions to promote the promulgation or amendment of rules that will reduce barriers to entry, open industries up. This sort of data portability would be an example that it will promote competition. To spearhead the legislative agenda that we've been talking about to reform the antitrust laws and modernize them, to coordinate action between DOJ, FTC, and various other executive branch and independent agencies to proactively address competition problems in industries and where various agencies can do that, and generally to pay attention and promote rulemaking to prevent rules that harm competition, particularly when there's overlapping jurisdictions, so we need centralized oversight from the White House. Now, in the last year of the Obama administration, President Obama did issue an executive order to increase competition throughout the federal government. I'm not sure there was really enough time for that to have much effect, but we're thinking of going beyond that by establishing an office and a function to really push that forward. And we thought that would fit well in the National Economic Council, working with other agencies within the Executive Office of the President to really corral agencies. Certainly OIRA and OMB need to be part of this because they're paying attention to regulations. So, Tim, you've also have experience at the NEC. How do you think the office would work? The EO that President Obama issued seemed like a really good idea, but I'm not sure how much follow-up there was, in part because of the change of administrations. What sort of benefits do you see here? How do you see this really making a difference? Tim.
Sure, thanks. So this part of the report, I think, is responsive to something we've, I think, said numerous times here, is that we think of the scope of the problem here as large. You know, if you're talking about a macroeconomic problem of uncompetitive industries, you know, the idea that, well, you know, we've got to win a few more merger cases, that'll change everything, is not really, you know, is kind of a teaspoon problem, a solution to an ocean problem. So I think this is responsive to the sense that we need a lot more in this area, and that we need a whole government effort. And I think that the idea of this office is to put the weight and the kind of the authority of the White House into competition policy, and keep it from being something where, you know, it shows up every once in a while as something that the Justice Department or the FTC are into. So, you know, how would this work? I envision, or we envision, that the office would be in the National Economic Council. You know, this would be a hard job for the office. They would face a lot of resistance. They're sort of trying to cajole agencies which have had their own agendas, their own ways of thinking about things, to try to do some of what we talked about earlier, as in kind of breaking open long closed industries, or avoid protecting industries that from competition in ways they might feel inclined to. So it is challenging. I also think there would be, in terms of all this legislative agenda we're talking about, including some of the stuff Ganesh talked about, you know, if you want to get more ambitious and talk about starting to introduce common carriage regimes or structural separation, the sort of bigger picture things, that would be something that this office is also interested in. I think I didn't say this is my view, not the report's view. I think they'd have a full agenda. Now, why do I think it'd be effective? I think, to return to my earlier theme, there's a lot of low-hanging fruit. So you mentioned that Obama administration effort. I was part of that in the sort of last days, and you know, everywhere we looked around, there were opportunities. We were, for example, concerned about craft beer, and it's just one example, craft beer industry, and whether the consolidation of the rest of the industry would make a difference. It turns out there's authority inside the Treasury Department to try to police the terms of competition in the beer industry. You know, these sort of small bits of statutory authority that lie dormant for a long time. You know, there's a problem with price gouging in pharmaceuticals that everyone knows is a problem. Even the Trump administration feels that's a problem, which says something. You know, airline pricing disclosure. There was just issue after issue after issue. I just think there's low-hanging fruit everywhere. I think this, you know, sometimes inside the departments, you get very fixated, inside the enforcement agencies, you get very fixated on a certain kind of problem. And the advantage of this office is, I think it would see and almost pull back the curtain on a series of other very serious things that inhibit competition in the US economy. So that's my case for it.
Fiona?
Yeah, the thing that surprised me when I was in government for the first time was not anything about antitrust enforcement. It was about how much I could not do, because most agencies in the United States, I think, are captured. They're captured and they serve the industries that they regulate, not the consumer. And I know that that's a broad blanket statement, but I'm trying to sort of focus attention on just what Tim said. There's a lot of low-hanging fruit here. So if you think about the FDA and the fact that biosimilars have a 4-letter nonsense suffix at the end of their name, so that you can't sort your drug database and find all the products that compete with one another in the same place. That's the kind of thing that the FDA does not need to do. And if you had a competition mandate that came down from the top, you could stop that kind of thing. Indeed, the FDA has access as part of its mandate. So there's, if you took that seriously, you could think about access being something that the FDA could balance against issues like REMS. You know, when consumers, when the drug is supposedly dangerous and the company applies for a voluntary REMS status, so that then the generics can't get hold of samples and can't enter the market. Okay, that kind of thing, we could have an antitrust case about it, or we could have the FDA fix it. So if you thought about the Department of Transportation and fees, if you thought about the Department of Transportation and the fact that airlines withhold the information about their schedules and fares from meta search sites so that it's hard for us to search. If you thought about the Department of Agriculture that puts fees on small farmers in order to market products that that agribusiness wants marketed, there's just an endless list of these kinds of things. And I think if you had a whole government approach to competition, there would just be a lot that could be done that was very effective.
Let me pick up on that because it's really ringing true to me, Fiona. When I was a member on the Council of Economic Advisors, you know, was involved with all the regulatory apparatus, OIRA and so forth, as well as a lot of other things. And you see a lot of agencies, and I couldn't agree more. Let me give my own example. It was during the Great Recession, and the housing market was a big issue, housing finance, and we were trying to encourage people to be able to refinance their mortgages because rates had come down so much. And there was a lot of pressure on homeowners. And it turns out if you want to refinance your mortgage, it was actually very hard to do it. If your mortgage was federally guaranteed, your existing lender could give you a new mortgage, but other lenders wouldn't be easy. So your existing lender basically had a monopoly. And so the lower interest rates, why would they pass them through to you other than enough to get? So I'm like, wait, this is crazy. We want to have competition, but there are all these obstacles. And that was a lot of money. So I think there are just many, many examples. And just speaking again, trying to speak for the report or the authors, we've seen so many of these that's why it needs effort and priority and a champion in the White House, the NEC, to do it, because otherwise it's not going to happen. Okay, this is just not where that wasn't the focus of the Federal Housing Finance Agency to do that. It wasn't just, the focus isn't there in these agencies on thinking about necessarily the consumers and competition rather than the industries that they're close to. So Ganesh, would you, I see you nodding, and you thought a lot about this. What do you think?
Yeah, so I think this is a terrific idea, and like many of my other comments, I think I agree and more. And the more here that I'll say, because I do think this is right, as a policy process, you know, you need somebody who is thinking about this and who has this as the one thing that they care about in the White House, and who would be able to look across all the different executive branch agencies to do this work. My and more would be that I think it would be a mistake for this office to simply or only focus on rulemaking and rulemaking opportunities, and not to see all the other different ways in which the federal government makes policy or impacts the structure and functioning of the economy. So a couple of examples, thinking about procurement. If the government does a significant amount of procurement in some areas, how does that process work? Who are they choosing? Now, there's a whole body of law on procurement, but is that an area that should be thought of in competition terms? It's something that I think an office like this could look into and think about procurement that advances competition goals. We have a competition chapter in trade agreements. It talks about competition in it. But surely all of the other provisions in trade agreements also actually have impacts on competition. So we shouldn't see this as something relegated just to the particular siloed chapter on that. It's actually throughout the rest of it. So I think across the board, there are potentially opportunities that are even outside rulemaking specifically. So yes, and is my general view.
Josh, do you want to comment on this proposal?
Yeah, I mean, sure. I think the professionals can correct me, but I think what you're describing is that when benefits are concentrated and costs are diffuse, you get kind of a massive failure in public policy. And that can produce a lot of anti-competitive effects, including higher prices, reduced output, lousy services, et cetera. So yeah, I mean, as a general matter, looking for instances to improve transparency in markets and making them more effective and efficient, I think is good. I think as Fiona is suggesting, people should wear their armor to the battles, because the battles within the government, regardless of who's running it, will be intense. And that you just want to make sure that when passing something that's designed to improve competition, you're not indirectly facilitating rent seeking and doing it.
Well, I think we're trying to do the opposite of that, and actually trying to undermine rent seeking. Okay, others on this topic? I mean, I'll just say, I'll add one thing and then look around the panel here. It does seem that there's I would hope the incoming administration would agree with all these principles, what we're trying to do here, because it is helping consumers, working class families, all that. It's really an administrative thing. How do you do it, given that everybody's busy and you know, just, I think as Ganesh said, you need somebody with high level instructions and power behind them coming from the top to say, this is something that's to corral the agencies, because otherwise they'll just ignore it or not bother to do it. And so it's an execution issue as much as anything else. And it's never been done very well, I think, in my experience.
Yeah, I mean, I think that's the primary challenge. It's easy to talk about on this panel. The challenge will be, you know, does the chief of staff really care about this? Are they, basically, you have to tell, you're trying to get someone in the White House to tell the agency what to do, who's not necessarily the president or the chief of staff. So the challenge is, and the industry isn't going to like it, and the agencies will have their own. So as I said, it is a question of the administration's willpower and its commitment to competition. I think that is that issue. But
I think it does also depend on what kind of people are chosen to be Secretary of Labor and Secretary of Transportation and Secretary of Agriculture. If those are people whose priorities are the consumer and the working families and so on, then this isn't an ask. This is what they would be naturally inclined to do. Yes, the industry they're regulating doesn't like it, but they already know that. So I think if you have the right sort of personnel selection at the tops of these agencies, that would make a big difference to how effective this kind of effort would be. Because there would be less fighting inside the executive branch.
I wanted to just amplify something Fiona put in the chat in case folks hadn't seen it. I think it's total. I mean, I think this is a really important idea. And I also agree that the implementing it is the challenge. But I think what I remind people is, compared to the status quo, even creating the White House office is a huge improvement, because right now, if you're at the FTC or the DOJ and you go to FDA or you go to Department of Agriculture, you go to Department of Transportation, you are an annoyance because you're just making their job more difficult. And so that already creates a burden to change. And so part of the thing is, as I see the inside of this proposal, is it forces people to look at issues that otherwise they wouldn't, because naturally we all like fewer headaches than more.
Yeah, the other thing is, I think there is actually a track record for how this works well and how it doesn't. That where to focus on the FTC, where the FTC has done well in this area is through very careful, consensus building, careful issue selection, where there's room, you're never going to get 100% on board, but you're going to get 80. And then, things move forward. And I think there are things like that where you can do that. Where things go off the rails is where you're trying to, squeeze the 51-49 issue through. And it doesn't mean the 51 isn't right, but you can do a lot of collateral damage if you try it and you don't work, and then you shut down the whole thing. So when you identify low-hanging fruit, I think it's not just the issues that clearly there's a big competition problem, but ones where in the real world you see a way through where you're not just sort of having a moral fight, but one that actually benefits tens of millions of people.
Well, I actually disagree a little bit with that, Josh, because I think that we know very clearly this is a little bit of a zero-sum game. We're trying to move the money from the profit column into the consumer surplus column. So you're not going to find too many cases where the firms and the consumers agree on what to do, because you're trying to move the money from one to the other. So I would say you can certainly achieve consensus among neutral third parties about what some change is going to achieve and which direction the dollars will flow. But I wouldn't want to go into this saying, let's achieve consensus with the industry before we change the rule, because I think that's exactly the opposite of what I had in mind anyway.
Yeah, no,
Let me move on. So
I'm a little more cheerfully optimistic about it, that there are areas where, for whatever reason, competition is stuck or the markets are opaque, where again, you're never going to get everybody, but you will get a critical mass needed to actually make it happen in the foreseeable future.
let me answer a question in the chat on this, and then move on to other questions. We have a question about why we propose these various offices within the executive office of the president be included in this Office of Competition Policy, but not FTC or DOJ. And the idea is that there are many agencies that will be outside the White House that will be interested in these rules or initiatives, and they'll be brought in as needed. But this is really, we just identified the offices within the EOP, the Executive Office of the President. But in one case it'll be Treasury, DOJ, and of course FTC and DOJ will be consulted a lot, with our view, because they're the experts on competition. Also the Council of Economic Advisors, because they care about competition as well. Let me turn to some of the questions. We have time for a number and still welcome more. So that we'll go back now to all topics we've covered. So one question is, if the courts are the problem, and we're turning to Congress, is one way to go to have a specialized judges rather than the generalized judges? This has been talked about certainly before. Obviously, I think it still takes Congress, but Congress could make that change rather than the substantive changes. It would be more of a change. So Tim, I feel like you're the first person I want to ask on the panel here.
Maybe they should have an administrative court inside the Federal Trade Commission that has to hear antitrust cases.
But those would still get appealed to, of course, those would still get appealed eventually.
You mean going all the way up into the
the appellate court after the commission, right? So.
Snarky answer, but having a full separate, I don't think that would be a good idea. And I kind of this is a more general question. Even though we often complain about judges being not understanding or ruling against us, specialized courts, I think just have the problem is the alternative. I think specialized courts get too fixed. I'm just thinking about the Federal Circuit and patent, and I think that the experience there has been.
Yeah, they got captured.
I think they're too close to the patent bar, and I think it'll just become. So yeah, I don't think so. I think get a DC antitrust court, staffed by. I just don't think that would go well, and it would develop its own jurisprudence in a strange way that would be too disconnected.
I like it. Sorry, Ganesh, let me say one sentence. I like it in the Stigler report where I worked with a number of people. We recommended this and tried to avoid Tim's critique by having federal judges sit on this for just a limited amount of time, like 5 years or something, and then go back to their bench. And I felt that would stop us from having to define market shares and the structural presumption and what is an HHI and these things that if once you've done it a couple of times, you could move past that. And the litigation strategy of try to confuse the judge would become harder to carry out, which is where right now it's a very excellent, profitable strategy.
So I think there's two problems with this that I see. So one is that you might want a specialized court because you think that the area of law is very complicated and technical. Another is that you want a specialized court because the facts are very complicated and technical. And that would be the case for specialization. And I think the problem here is that both of these are problematic. On the first side, why would we want judges, we don't think this is a particularly specialized area. To the extent that it's common law, we should address it through rulemaking or through Congress passing new statutes, as I think the report suggests quite well, and that would solve that problem. And it would also alleviate our fact problem. But separately, even if we didn't do that, the problem on the fact side is whether you're studying, to go back to some of our classic cases, American Express, Vaughn's Grocery, what else has come up in our conversations? Pants, men's trousers. These are all different fact patterns in different markets. So even a specialized court, unless we wanted to create a court for technology, a court for agriculture, a court for trousers, it's not going to really solve our fact problem either. So in both cases, I think this is why we have administrative agencies, and we have them to make these kind of determinations, to do the serious investigations. I think that's a strong case in the report for moving more towards rulemaking and to more resources for the administrative agencies. But it is a shift away from this model that says we should leave antitrust to the courts. And I think that is part of what our problem is in this sector, is for too long antitrust has been left to the courts, not to democratically authorized and responsive policymakers who have greater expertise and who can actually do the work to really understand the markets.
We have time for one last question. How this is from David Picozzi. I'm just going to read it precisely. In your view, does the DOJ Google case signal a paradigm shift in antitrust prosecution in the United States? And then you can take that wherever you want to go in terms of what we're doing in the report. Fiona, I know you've written about these things, so do you want to take this on, or maybe you don't? I don't know.
I actually think that it's the House report that signals a real change in the way antitrust enforcement is thought of in this country. I think that report is just incredible in the way that it harnesses small businesses on the side of consumers. So when you watch the Republican response to that report, my general view is Republicans don't care too much about consumer welfare, but there are a lot of small businesses and medium-sized businesses, and indeed the businesses that aren't the top 4 in every state. And therefore they have senators and representatives who care about their welfare. And once you start dividing the top 4 platforms from everybody else, then you get a coalition of the consumers and most businesses that are interested in antitrust enforcement and would benefit from antitrust enforcement, because those markets then become more dynamic and thriving and more efficient. So I think that to me was the moment when I thought, actually, we're seeing a real change in the way like the bulk of the policy community might be looking at this problem. I think it's really striking.
Tim, I want to turn to you on this topic as our last word, and after that, we'll go back to Michael for wrap up.
Yes, I do think it's a paradigm shift. To give credit where it's due, I think, I guess I'd say the antitrust winter is over, the Section 2 part of it at least. There hasn't been a major Section 2 case since the Microsoft case filed in court. And I think it's a big moment. And I think Justice Department, maybe I shouldn't say, a little surprised at the strength of the complaint myself. I thought they were going to do something a little different. And, they seem to have, I don't want to get in the merits of the case. I think it's a big deal. I think the traditional role of Justice Department is bringing blockbuster cases against dominant monopolists with exclusionary deals. And, this case could have also been filed in 1911, 1908. It's a classic style of antitrust case. And I think it returns, and America is all about reruns and returning to roots. And I think that's what this case does.
Okay, thank you, Michael. I am officially ending my tenure as moderator and turning it over to you to wrap things up.
Great. I've really enjoyed this has been a fabulous birthday present, just having this event. And I've really enjoyed the conversation. I hope all of you have, and I appreciate all of you who've tuned in and staying through the end. I hope you've learned a lot, and I hope I encourage you to go read our report. And with that, have a great weekend and a happy Thanksgiving.